have to spend a lot of time, but the figure you're seeing there, it's a classical illustration of a fiscal regime in the oil and gas industry. There's what they call a production sharing agreement. That is the contract that the oil companies enter into with the government, streamlining how oil and gas operations would be conducted. And when oil and gas production commences, there's what we call a first tranche of payment, which is a royalty. So government receives a royalty from this gross production, and that royalty essentially is to manage expectations of the citizens. As you will note, the oil and gas industry is long term. The oil companies take time to get profitable. So if the taxation regime was in such a way that the government can only start to collect taxes at the point when the industry becomes profitable, the citizens, in light of the excitement and expectation oil and gas discoveries create, would not appreciate that. So things like royalties are to manage that. That even as production commences, as oil companies recover their costs, the government should be able to receive some revenues that are able to help it manage its expectations. So those are the royalties. Then oil companies under the regime that we use for exploiting and managing our oil, there's what they call cost recovery. So a lot of the costs that the oil companies incur are recovered if a discovery is made and proceed to production. Then there's what we call when oil companies have taken away their costs, what remains is what we call profit oil, and that profit oil is shared between the government and the oil companies, and that profit oil is subject to income taxes, but I'll explain further as we go on. So Uganda's fiscal and taxation regime has a number of instruments embedded in there, and the first one I've mentioned is royalties. So royalties can be specific or ad valorem. They can be sliding or deduction of expenses or profit-based system. I'll not go into the technicalities of all that, but all I can say is that Uganda has a sliding scale royalty scheme. So depending on the production stratas of oil, then the government can get royalties. Then we also have a resource rent tax. Initially we did not have it, but in 2021, when final negotiations before we got into FID final fiscal negotiations were being concluded, the Income Tax Act introduced what they called a windfall profit. So if at any point in time crude oil prices exceed $75 per barrel, the government will be able to tax anything over that. Of course, the fact that the oil companies were able to accept that means that in the negotiations, government must have adjusted some other aspect of this fiscal regime, because the reason why our final investment decision delayed was the struggle to achieve a rate of return of around 15%, which was required for the oil companies to sanction FID as a benchmark that the shareholders had set. So they had to go through the fiscal regime, the income tax rate, and all that to ensure that that rate of investment was achieved. Then there's what we call state participation, and this is where you see the Uganda National Oil Company take part in the oil and gas sector. So governments in Uganda is participating in the oil and gas sector through Uganda National Oil Company. Then there's what we call auctions and licensing rounds. It's a means of streamlining the award of oil rights, oil license rights, but it can also help earn revenues for a country. Previously in Uganda, we had first come, first serve. I mean, an investor would come and move in and suggest that I've had this oil in the western part of Uganda, why don't you allow me go in there? Or government would run roadshows. But when the area was de-risked and discoveries were made, government shifted and went to a licensing round where companies come and compete. And the beauty about this is that if you have oil companies that have all the knowledge in geological terms come and bid, you would expect that whatever figure or whatever deal the oil company is presenting is a reflection of the commercial reality. And when you go to countries like Angola, there's a time Angola ran a licensing round and it earned a signature bonus on signing the agreement of about $1 billion. So even in Uganda, we earn in the licensing rounds when they are concluded, the government earns some signature bonuses. So cost recovery, I've already explained that most of the costs that oil companies incur are recovered in the form of cost oil. It's not that the government pays money to you, but it's computed and determined, and you pick oil, and that oil is actually, as I'll explain later, part of the gross revenues for income tax purposes. Then signature bonuses. When you're signing production sharing agreement, government can earn from that. Production bonuses, when production commences or when production reaches a particular milestone, the government can actually be paid a bonus. Then this corporation income tax, it's a means of government extracting value from the oil and gas sector. So when you look at Part 10 of Uganda's Income Tax Act, it exhaustively deals with how oil and gas operations are covered. Then there are also import duties, though we have a special regime, as I'm going to explain, relating to oil and gas. Then withholding taxes, when you're making payments to from Uganda to foreign vendors who are providing services, or even other payments like interest, royalty, and dividends, they do attract taxes. Then VAT regime is a bit tweaked to accommodate the special features of the oil and gas industry. Then number 14 is the fiscal stabilization clause. I wouldn't say it's exactly an instrument, a fiscal instrument, but certainly why it's finding itself there is it's very difficult for any major investor to conclude a project investment agreement without including a stabilization clause. And what a stabilization clause does is that if at all there's a change in the law, and that change in the law affects the economic share or what was previously computed as would be the return on investment, the investor has a right to renegotiate with government to restore the economic balance as it was previously. Now, fiscal stabilization clauses have evolved over time. So when you look at our agreements in the law, you find an economic stabilization clause that helps you renegotiate with the government to restore the balance. But in some countries, there's what they call a freezing stabilization clause, which would mean that for as long as that project is ongoing, the government cannot change the tax laws or any law that would have an impact on the economics of the project. So this brought about issues of sovereign rights, and it was a contentious issue, so that's why they've moved and evolved. Then you have capital gains taxes, and this has been a subject of enduring controversy in Uganda, especially on farm-out transactions, starting with Heritage Oil. Even when Talo Oil farmed out to Sinok and Total, it was a problem. Even when Talo Oil was exiting eventually from Uganda, it was still a big issue. Though, I mean, a deal was worked out, we still have challenges in the law. I think the issue of farm-outs has not been exhaustively covered under the law in the Income Tax Act. Then you have annual fees, which are essentially covered for under the production sharing agreements. So an oil company, the acreage it has every year, it has to pay those annual fees to the government. Then stamp duty, like it's applicable to the other sectors of the economy. It also applies to the oil and gas industry if you have chargeable instruments that are subject to that. Then local content can actually be also a fiscal issue, because you might find that, I think there's a policy, Uganda is mooting the establishment of a local content fund. And in that local content fund, I think the oil companies would contribute, I think, about 1% of the contract sum. And then also the subcontractors themselves would contribute that, and then the government would collect this money, and this government and this money would help in building local content. So it's a policy which is being discussed, not yet determined, but if it takes that route, then it takes on a fiscal dimension. Then local government taxes. So local government have varied local government levies. So I have that table, and that table is showing the fiscal terms in Uganda's oil and gas regime and vis-a-vis how other countries in the region do it. Now, when you look at Uganda, we do have royalties. Even Tanzania has royalties. Kenya, under the old regime, did not have royalties. And I remember around 2016, there was a screaming headline in the newspapers, the Standard to be particular, saying that Kenya was going to lose so much money because it didn't have royalties in its fiscal regime, which wasn't true. The fact that Uganda has royalties and Kenya does not mean that our fiscal regime is superior. There's always a balance. Kenya may not have royalties, but it has maybe a much higher cost recovery cap. And Uganda, which has royalties of maybe up to 6%, you find that the cost recovery cap is relaxed so that you have a balance. So then there's cost recovery. The oil companies, when they make a discovery, they are entitled to recover a significant chunk of all the costs they've incurred. And that's what we call cost recovery. Of course, what would happen is that if you allowed oil companies to recover all their costs at once, it would mean that the government would not be left with anything. Because if Uganda's oil and gas project, you've incurred $20 billion, every year the annual revenues from oil and gas production would probably not exceed 1 billion. So if you let the oil companies fully recover all their costs at one go, the government will not be left with anything. So that is why there's what we call cost recovery caps. In every year, an oil company would recover maybe up to 50%, so that the other 50% is left for the government to share, part into it, and then also for the oil companies to have profit oil, which can be subject to income tax in Uganda. Then local content, it cuts across in the region. State participation cuts across in the region. Annual fees, it cuts across in the region. Bonus payments in the form of signature bonuses or even a discovery bonus when oil and gas discoveries are made, or even production bonuses, it cuts across in the region. Then additional profit taxes, yes, Uganda has it since 2021. That is if oil prices exceed $75 per barrel, the government can collect more funds. Tanzania has it. Kenya also has something like that under its older PSAs. South Sudan, it's not there. Then cost recovery, cap and limit, that's what I explained earlier on. It cuts across. So oil companies cannot recover all their money at one go. It is staggered by restricting what it recovers every year, so that so that the government can have some revenues flowing every year. Then profit oil, yes, it cuts across. So when you have a cost recovery cap, it would mean that there will be some oil that will be left, profit oil that is shared between the government and the oil companies. Then there's what we call ARA factor. ARA factor is a brainchild of largely IMF. And what is ARA factor? ARA factor, the idea is that to make the oil and gas industry a little bit more predictable, then the error factor should be employed, and the error factor is essentially a ratio of it's a ratio of revenue vis-a-vis your investment. And what that means is that if the ratio of expenditure vis-a-vis revenues exceeds 1, it means that the oil companies have recovered their costs a little more profitable. If the ratio is less than 1, it means that the oil companies are still spending money and they're yet to achieve profitability. So in those instances, how you allocate a share of the oil, it should reflect those realities. So Uganda doesn't have the error factor, but when you go to Tanzania, there is. Then ring fencing, as I explained earlier on, we have blocks, oil blocks. Like presently, we have 3 blocks that are being developed, 3 areas, 3 license areas. And for oil, for tax purposes, you prepare different P&Ls for each. But for accounting purposes, you do a consolidation. Now, when you look at the Income Tax Act, we do have ring fencing, yes. The blocks, the oil blocks, are ring fenced. So you might find that block 1, when commercial production commences at some point, could be profitable, but the other block is not profitable, and then block 3 is profitable. Of course, ring fencing, the proponents of it suggested that if you allow a consolidation, then a country may find itself in a position where it is not getting any oil revenues because any income taxes, because the significant losses that are being incurred in one block can be in sucking away any profits that would arise from the other. So it's for that reason that it was devised that do a ring fencing of a block by block. Of course, I mean, it's good, but you also need to look at your realities and circumstances as a country. You might find that sometimes you actually have to go that way of eliminating ring fencing, because you might have some frontier blocks, not exactly very profitable, but if you allow the oil companies to consolidate through, then you make it profitable. So there's no one size that fits it all. You have to examine your circumstances. Then capital gains on farm outs. This has been the most problematic issue in the oil and gas sector. And I think from 2009, when it became apparent that Heritage Oil was going to exit Uganda, there was an amendment in the law, Income Tax Act in 2009, to ensure that when Heritage Oil was exiting, the gains that they made on the transfer of their license interests were not taxed, were taxed. Previously, the law would not tax them. And of course, when Uganda took that step, it triggered off a series of regional responses. I mean, we saw Kenya introduce a withholding tax on farm outs. Tanzania did the same. Mozambique did the same. And of course, farm outs, previously, they were not well understood, but now they are well understood. They are understood. When oil companies were selling off some of their license interests, initially, I think the view was that, oh, these people are already making money as oil companies, even before the government can make any money. But farm outs are quite common in the oil and gas industry. In the oil and gas industry, because of the risk associated with exploration, the early movers in the sector are the small companies, the smaller companies. The smaller companies usually have bigger appetite for risk, and when they come and make a discovery, that attracts the bigger players who then come and acquire a stake into those projects. Like if you look at Uganda, I think in 1997, we had ADF rebels in Western Uganda. And if you're having ADF rebels in Western Uganda, how would you expect someone to come and a serious company to manage that risk? So there was Heritage Oil, which had the risk appetite. They came and started, I think, exploration around that time, 1997. That's when they signed their agreements. and then 2001 is when they started real activities. So that is why we keep saying that if the oil and gas taxation regime is not well aligned on farm outs, you can actually cripple it, because M&A activity is the gist of the oil and gas activities. Smaller players initially come in, and then you attract bigger players. And then also, it's also a means of raising revenues. And if you remember, in 2018 and 2019, the fallout between government and the oil companies was largely as a result of this. Tullow Oil had initially not intended to exit Uganda. Tullow Oil had wanted to stay in Uganda, but significantly cede away a significant part of its rights, and the consideration it would earn from that would actually be used to finance their share, of course, in the investment phase. Of course, our law, as it was structured then, required taxing those revenues. And the question which was arising was that, is Uganda's tax regime taxing profits, or it's taxing capital earmarked for investment, which was the case in that regard. And then also how tax losses were being treated, because for the oil and gas industry, exploration expenditure that you incur is written off immediately. So you find yourself in a tax loss position, even though you do not have any gross revenues. Now, Tullow Oil had gross tax losses, and those tax losses would not be transferred to anyone. Now, if Total and Sinopec were to acquire Tullow Oil interest, it would mean that as they would recover the cost oil from the government, cost oil is included as part of the gross revenues. It's profit oil, cost oil, but in arriving at the taxable profit, a lot of the cost oil, because it's cost you've incurred, would actually come in out as your expenditure. But now Tullow Oil had already written them off as exploration expenditure, and those were tax losses. So it would mean that Sinopec and Total would not have the benefit of utilizing those. So they would have a cost oil that would be taxed, yet they also spend money. So it created big issues in relation to that. And to date, an issue that we raised is what we call work obligations. An oil company might have a license, but it doesn't have the money. And to ensure that activities move on, they would get a deal, enter into a deal with another player to acquire part of the license, and the obligation is to fund the work obligations. Now, when you fund the work obligations, that typically, if we had to spend $80 million to develop, to undertake exploration activities, and I, as a licensee A, I don't have the money, and I bring on another party, you would say that is consideration, because you're taking on an obligation that ordinarily I was supposed to take on. But if you subject it to tax, if you look at it as taxable revenue, then it creates a challenge and an issue. Then do we have capital gains? Does the capital gains rollover relief potential apply? Yes. Then there's what we call a tax paid production sharing contract. In Uganda, it doesn't apply, but when you go to Kenya, they had it, or even countries like Egypt. Now, a tax paid PSA, it would mean that whatever the oil company gets as oil is already net of tax. And the idea behind that is that if you go into a tax paid PSA, then you minimize the appetite of government to keep changing tax laws, because whatever I get is deemed to be net of taxes. And some countries, some oil companies go for that as a means of managing political risk. Then indirect disposal of license interests, assuming Tullow Oil, the disposal took place in Netherlands, would Uganda have a right to tax? Yes, it would, and it's covered under there. Then withholding tax, the way withholding tax works in other sectors of the economy does not differ from how it works in the oil and gas sector. The rates might change. I think for service fees it's 10%, while for the rest it's 15%, but largely the obligations remain the same. Then there's what we call a variable rate of income tax. income tax. We don't have it in Uganda, but previously, I think before 2015, for the mining companies, they had it. The mining companies, you could either be taxed at a higher rate of, I think, 40, a rate higher than 30%, and the rate could even go low as 20%. But we don't have it for oil and gas. Then transfer pricing, yes, it applies. The double tax agreements, yet it applies. Then additional profits tax, we have it in the Income Tax Act. Then in the VAT legislation, there's a long lead time between investment and production. So for that reason, because of the long lead time between production and investment, it would mean that typically the way how VAT works, you only register, you would only register if you're in production. You have a taxable supply you're making. But the oil companies would never have the opportunity of getting into that because there's a very long lead time between investment and production. So for that reason, Uganda's VAT regime has adopted a special regime that works for the oil companies. Of course, it's been a long journey to this, and this was one of the sticky issue. I think in 2010, the law was amended. Was it 2010 or 2011? Where the investment trader facility was eliminated. And this is how oil companies previously would register. Previously, they would reclaim VAT that they had incurred on investment activities, but it was eliminated. And between 2011 up to 2015, when the oil companies were considering final investment decision, there was a big debate with the government, because they were telling government that because of the VAT regime, the project numbers were not adding up. Because if they're going to spend $10 billion, assuming all that is subject to VAT, they would incur an extra 1.8 billion in VAT costs. So what we have as the VAT regime is oil companies can voluntarily register for VAT if they so wish. And if you register for VAT, it would mean that if there are any pass-through costs, VAT costs that you incur, you can claim a refund from VAT. But a system that they applied that works is what we call the deemed VAT regime, or VAT paid. So someone, your vendor is going to issue an invoice with VAT on, but that VAT, the law deems it to be paid, and that alleviated a lot of challenges, because if you had not treated it as a deemed VAT paid, you'd create a refund challenge. The oil companies would have to go to URA to claim for a refund, and you know the challenges in terms of managing the administrative aspects of this VAT refund. It's just not easy. So that's how the deemed VAT paid regime deals with the issue. Of course, there's an issue I see in practice for the upstream project, that is the Tileng and Kingfisher, and not the ECOP, the pipeline. The VAT deemed regime only extends to Tier 1 contractors. So the Tier 1 contractors are those contractors that directly have contracts with the oil companies. Now, if those contractors themselves hire other subcontractors to undertake the oil project works, they would have to be charged VAT, even if their only exclusive client is the oil and gas client, oil and gas company, and even if the works that are being undertaken are to serve the oil and gas company. So this is creating a bit of cash flow constraint for them. It's not the same with ECOP for the pipeline project. At least the deemed VAT paid regime stretches beyond Tier 1 contractors up to Tier 2 contractors, unlike the case in Uganda. And from contractors, I am seeing contractors do not understand well, or the subcontractors to the oil companies do not understand well what the deemed VAT regime means. Because I think they take it zero rate. They treat it as if it's zero rated. So for some of the bidding that they have participated in, they've found themselves hit. Because if you're asked to quote a price inclusive of tax, how are you going to treat the deemed VAT paid regime? Would you say, because it's deemed VAT regime, the tax rate is 0% or it's 18%? So for that reason, if you're quoting a price inclusive of VAT, an oil company would potentially argue that the price you've quoted also includes 18%. And therefore, when I'm paying you, I have to pay you less, 18%. In practice, that is what I've seen the contractors grapple with in relation to this VAT. Then customs legislation, the law has been streamlined to mitigate the project costs, because a lot of the equipment that is coming in required for the project would be subject to import duty at a higher rate, but we do not have this equipment, and it would not make sense to charge it because you're only escalating project costs. I know the government would say, but whatever the cost the oil companies are incurring is cost recoverable. But while it is true, when you're doing a project crunching, trying to see the net present value or the payback period, if you do not minimize the costs, the outlay of costs before production, then you mess up those numbers. And I think it made a lot of sense to exclude that, which Uganda has done. Of course, the challenge in practice is that when you look at the fifth schedule to the East Africa Customs Management Act, I think part item 30, it talks about licensed oil company, that the exemption from import duty is only applicable to those equipment that have been brought in by licensed companies upon the recommendation of a competent authority. Now, who are the licensed companies? It's typically Total or CNOOC, because these are the companies that have production sharing agreements. But the players who are bringing in item to work for Total and CNOOC are the subcontractors. It's the ZPEBs of this world. It's the McDermonts of this world who are bringing this equipment. So strictly when you look at the law, you would say that those subcontractors are not covered because they are not licensed parties. And what they do in practice is that these items are consigned through the licensed companies. So you bring the item through CNOOC or Total. It has its risks, but so far it's, I think, the way it can be done. Because if URA is doing an audit, the import of record would be Total, but the owner of the assets is actually McDermott. So if you're doing a post-clearance audit, who do you hold accountable if some issues do not go right? More to that, supposing, can URA also say that there has been a disposal of assets? Because we are seeing these assets being brought in under your name. We are not seeing them on your books. We are seeing them on the books of the other parties. So it's been, there's been a lot of back and forth in terms of trying to see whether URA could include even the contractors, subcontractors. But the concern URA has had is that if you extend it so widely, it can easily be abused. Because just imagine if every contractor can have this exemption. They can bring in items that are not even related to the oil and gas project. Then I don't think we really have to go through that. The other fiscal tools, domestic market obligations, the withholding taxes, environmental taxes, maybe bilateral investment treaties. This is quite key. And there's a reason why the ECOP company, holding companies in the UK, there's a reason beyond the double tax agreement why a lot of investment for infrastructure is routed through either UK or Netherlands. It's because these countries have bilateral investment treaties. Now, what a bilateral investment treaty does is that it enables the investor to directly take on government in case some of their rights have been violated. So that is why investors clamor for those holding jurisdictions because of that right to take on the government in international arbitration. And as you realize lately, if you've been involved in negotiating infrastructure agreements, the government seems not keen to permit arbitration. It's quite difficult nowadays to get an arbitration clause in the agreement. But if you have a bilateral investment treaty, even if you don't have it in a project agreement, the fact that I am in a jurisdiction with a BIT, arbitration is an automatic right for me. And why arbitration is key is that even if you have very good instruments or very good terms like stabilization clauses or rights, from the perspective of international investors, they prefer not to adjudicate locally. They prefer to adjudicate internationally. So bilateral investment treaties, though not directly a fiscal issue, but it comes handy because if you have a big tax dispute or any other disputes around the production sharing agreement that require adjudication, you have a right to take it to international arbitration. Then, as I'm about to wrap up, ECOP. So the ECOP, the ECOP project also has its own regime, and that regime is found in the ECOP Act, the provisions of the intergovernmental agreement between Uganda and Tanzania, and the host government agreement with the oil companies and Uganda, and then the oil companies and Tanzania. When you look at the clauses, the fiscal clauses or tax clauses in the ECOP Act, they're quite well streamlined, and they're also, I mean, you're tempted to say it's such a good deal, but of course, why are they very well streamlined? There were so many challenges in the upstream sector, and those challenges gave the negotiators the opportunity to get right what the gaps were at the upstream. That explains why for the VAT regime, you find that the deemed VAT does not only apply to Tier 1, it also applies to Tier 2 to address some of those issues. And of course also, the reality of the situation is that if you do not have a refinery, you need to have a pipeline. If you do not have anything, it would mean that you cannot commercialize your resource. It means that your oil is going to be stranded in the ground because crude oil, you're either going to sell it as crude oil or you're going to refine it. Now, I think at the time of negotiating this ECOP deal, there was a realization that achieving financial closure was not going to be very easy because of the globe in which we live today. The environmental lobbies are quite strong, and therefore it did not make sense for you to saddle this project with costs that are accruing from a taxation regime. So you find that it's a fair position in terms of taxes, and the tax regime essentially was aimed at minimizing project costs, but then also bearing into mind that the value in the oil and gas project for Uganda is not this pipeline. A lot of the money is made at the upstream. The pipeline is just a conveyor belt of this oil. It's just to enable and facilitate the project. So when you look at the law, the ECOP Act on taxation matters, the ECOP Act takes precedence. When you look at the pipeline ownership structure, the entire pipeline is to be owned by a project company incorporated in the UK. But you have branches of the same in Uganda and Tanzania. In the negotiations before, this was a sticky issue, because government was of the view that no, the ECOP company has got to be incorporated in Uganda. And government's concern was that if the company is not incorporated in Uganda, then it would not be tax resident, that it would potentially miss out on some of the revenues that accrue from that. So as a compromise, it was agreed that you have branches in Uganda and Tanzania, but let the management and control of the company be exercised in Uganda so that it's resident for tax purposes, but incorporate it in the UK. So that is how it was. And then there was also this issue, the golden tulip issue, because there's what they call offshore companies. And if you interact with oil people, they have a funny sense of humor. And that is why even the names of the items, you have Christmas tree, funny names, which you can't easily fathom. So I'm imagining why, because initially it's an offshore company. You just go get a company which has already been incorporated, and then you change the name and the directors. It's quicker and easier to manage. So I'm imagining, it's not a story, but I'm just imagining how it could have happened. Maybe the project developers were like, we need to have an offshore company as we finalize the project in Uganda. And then the name that came into their mind was Golden Tulip. Probably someone had even seen it in Uganda. Oh, you had even slept there. And I was like, why don't we call it Golden Tulip? But it did not mean that the owners are Golden Tulip ABCD. It's just that it ended up being like perceived like that. Then interest in the project company, capital gains. It deals with capital gains. Same story. I don't want to go into it. Then the non-taxable transfers, I don't want to go into it. Then income tax holiday, it has a 10-year tax holiday. It looks excessive, but I mean, as I've explained, the understanding behind negotiation of this was, how do we keep the costs as low? How does tax do not interfere in the project costing? Then allocation of revenues and expenses, that previously was a big issue. You know, the pipeline, Uganda, I think only hosts about 15% of the pipeline, with 85% hosted by Tanzania. Now, there was an issue in terms of the revenues that this EACOP company would make. How would this revenue be allocated between Uganda and Tanzania? If the late John Pombe Magufuli had been petty, he would have insisted for 85%. But because he really gave his all to the project, they agreed 40%. So the revenues and expenses of the pipeline are allocated at a ratio of 40 to 60%. Tanzania taking 60 and Uganda taking 40%. Then customs, there are no customs taxes similar to upstream project. A lot of the import duties are not applicable for equipment that is going to be used in the construction of the pipeline. Then the withholding taxes, a lot of the withholding taxes are not there. They are exempted. When you look dividends paid by the project company shareholders, it's exempt. The tariffs, goods, a lot of the withholding tax has been excluded. So VAT, we see the deemed VAT regime being borrowed here, and it extends to both Tier 1 and Tier 2. And then maybe what is unique here in terms of fiscal is the NSSF. When you look at the NSSF Act, it's possible actually, I think if the Minister of Finance confirms that you're contributing to a scheme that is similar to Uganda and the MD of NSSF gives you an exemption, then for expatriate staff, you don't have to contribute. But for the EACOP project, it comes out fairly clearly that all expatriates who are being employed under EACOP project would not be subject to NSSF because they are already deemed to be exempt under that provision of the NSSF Act. This is quite a difficult issue because a lot of the commuters or rotators, people who are working in the oil and gas industry, are like secondisia. They are based in their home countries where they're contributing social security. And the way the law is in Uganda, there's just no way around going away from paying NSSF unless if you've got that exemption, which is also in practice very difficult to get. So I think I will stop at that. I've not delved so much into the actual nitty-gritty provisions. I just wanted to give a high-level view because there's not a lot of practice. I mean, the interface with oil and gas issues is quite limited, and so I just wanted to give a high-level view of the story behind the oil and gas tax regime in Uganda. Thanks.
Thank you very much, Dennis. That was more than a high-level view. It was actually an in-depth analysis. You've really done justice to the subject, and like you said, oil and gas is not really, there's not a lot of interaction with the sector, but I'm sure all the participants would agree that they've really gotten an insight, even to the sense of humor that resides therein. We have a number of questions, and I'll just read through. Okay, so the first question we have is really from Juma Bully. He's asking, could you please shed more light on why Talo left Uganda? The other one is from Moses Lugaizi from BDO. For farm outs especially, that was between Talo, the transferor, and the transferee, Total and Sinok. How costs are to be allocated between the transferor, Talo, and the transferee, because this is not clear. The allocation of costs for the year in which a license transfer occurs would only affect the annual depreciation allowance to be attributed either to the transferor or the transferee, since other costs are clearly attributable to the party who incurred them. The question then becomes, should the transferee contribute to depreciate or amortize the asset in the same way as if the transfer had not occurred, or should the depreciation be attributed wholly to the transferor, or should be apportioned between the transferor and the transferee on a time basis? Could this be the deal breaker? Was this a deal breaker for that transfer? We have another question from Juma. Let me read these three, then we'll add some more. Based on the fact that a lot of work in the oil and gas industry is done by subcontractors, has you already considered extending VAT deeming to subcontractors? So we could respond to these three and we could take more after that. Yes.
Thanks, Juma. Why did Talo leave Uganda? I think we all saw the statement that they issued. And of course, statements that oil companies issue are very well drafted and very well balanced. So I think the biggest challenge that Talo had here was how to invest in the development phase of Uganda's oil and gas project. And to invest in the project, they had to participate in the cash calls, which, based on how they were performing on the stock exchange, or even when you looked at their books in the UK and Ireland, I think they were, if they were to take on the Ugandan project, they would be stretched. And then I think if you also looked at their books, they were highly leveraged. They had significant debt. And then also when we went into lockdown, the COVID period, and crude oil prices tanked, all oil companies were stretched, especially those who are highly leveraged. They were really stretched in terms of how to raise financing. So I would imagine possibly the challenges around financing, their share could have been a key driver for them to move away. And as all companies say, rationalize. I mean, don't spread so thin. So rationalize your assets so that you concentrate and focus on those that are producing, rather than take on additional assets that are yet to produce, that would require probably you to get more leveraged, and even your sustainability as a company would come in question. Then regarding the farm out of 2019, it was quite. It's among the many issues, among the few issues that actually thawed relationships between government and the oil companies, with the oil companies halting altogether their activities, and then procurement and ECOP procurement in 2019. And I think that's the point at which commentators spelled doom for Ugandan oil and gas sector. They were saying this is not going to happen. The fact that the oil companies have now moved, relationship have completely broken away. This can't work. Now, in terms, of course, one of the main issues was that Talo farm out. You could not move to final investment decision unless if the ownership of the licensed interests had been ascertained. And I think Talo, since 2017, had always wanted to exit, or actually not exit, had wanted to dilute a significant part of their interest in Uganda's oil and gas sector, and that was pending government approval or government consent, and this consent wasn't easily and quickly forthcoming. Now, in relation to that farm out, there were, I think, about 2 or 3 issues which were contested. Now, from a policy level, from a high level point of view, if it was ascertained that the funds Talo Oil was going to collect from that farm out transaction were actually going to be reinvested in the sector, then it wouldn't have been fair from a policy level to subject that to tax at the rate of 30%, because that is money earmarked for investment. And if you're taxing money earmarked for investment, if you take away 30% and I needed 1 billion, which I've collected, and you take away 30%, it would still mean that I probably have to go borrow the other 30% to make it the 1 billion, which wasn't in good policy test. Then I think secondly, the other issue was that if there was any money that was not going to be subjected to, that was not going to be spent on the industry, you could isolate it and probably look at that as the item that would be taxed. But then also the other issue, which was a bit contentious, I think for the players that would remain, would be how they would be taxed going forward. Since 2015, exploration costs, which are incurred by oil companies, are written off immediately. So it would mean that when you look in the books of the oil companies, they have a huge tax loss. Now you have Talo Oil, which is exiting the market, but it has a tax loss, which is arising out of exploration costs that they've incurred. Now those exploration costs that they've incurred find their way into the cost expenditure, or the statement of expenditure, which is presented to the government of Uganda as cost recovery. And then when oil production commences, they would be entitled to that cost oil. But cost oil, even though it forms part of the gross revenues, it comes out because it's expenditure. Cost oil, essentially, it's in and out. It's oil you've collected as a result of expenditure you've incurred. And because it's expenditure you've incurred, for tax purposes, you would also recognize that as an expenditure. And what would essentially remain as taxable would be the profit oil. Now, I think the oil companies, the challenge they were going to have would be that when you take out tallow oil, you would be entitled to their costs that they've incurred, the costs that would come into your books. But the costs of farm out or farming in is not a deductible expenditure. So in their books, they would have a cost oil that they would book, but they would not have any expenditure to it. And that expenditure was already taken into account by tallow oil as a tax loss. So I think the law as it is, of course you cannot transfer tax losses. That was the right position. But it became quite a context. And because our farm out laws are not elaborate and are quite minimized, it was actually going to create, it was not going to make good economic value for the players that would farm in, and that's why it aborted. And then also secondly, I think government was demanding for about, is it $167 million as the tax from tallow oil farm out. And then tallow oil was willing to pay about, this was in public domain, I wasn't part of the deal, so I'm not speaking any confidential information. It was in media. So I think Tullow Oil was willing to pay about $82 million, which the government declined. And I think one of the other players even offered to top up to pay the 85 to make it the 167, but government and the company would not easily agree on how to word it or how to term that as. So the deal aborted. And of course, interestingly, when the deal aborted in 2019 and eventually happened in, was it 2021 during the lockdown, government ended up, I think, taking about $13 million. So they lost the 187 and took $13 million. And I think many times, some of us at that point in time were quite vocal when this was happening. What we're urging government and all companies to do was that, guys, do not apportion blame. Let's look at the commercial realities. Does the tax regime affect the numbers? If it does affect the numbers, then work out a deal so that you make this work. Does it help you achieve the return on investment of 15%? And then also probably I've remembered something I had forgotten. You know, the oil and gas industry in Uganda is the only industry sector where as soon as oil production commences, they'll be paying tax, or regardless of the fact that they'll not be profitable, because they will have spent up to $15 billion. To recover $15 billion for you to be strictly profitable for that purposes, it would take you beyond 7 years. But the oil companies agree to that. So the profit oil that they earn, as soon as oil production commences, they'll be paying 30%. Now that does not mean that the oil companies negotiated badly, or it does not mean that the government of Uganda has the best deal, and therefore even other countries should adopt it. It was, I think, a measured position, because when you're sitting down, you're like, what can I give? What can I take? Am I able to achieve my rate of return of 15%? Yes. If I'm able to achieve the rate of 15% as an oil company, the shareholders are happy. But the government will also tell you that there are expectations of the people. We need to construct roads. We need to have some funds. So if we are not able to take money from the very outset, it would mean we'll not be able to do that. How do we achieve that? So I think that was the spirit. It was a give and take to be able to arrive at that. And this is where actually that issue of whether to tax profits was a contentious one, because I think before 2015, that was the position of the law. But when the law was amended in 2015 following a World Bank mission, it was changed. And oil companies would then only pay income tax when oil production would only pay income tax when they were fully profitable. But it still found its way back into the law in 2017. And at that point in time, we told the government, you're not going to have FID unless if you have agreement on this, which, of course, eventually there was an agreement to retain it, but it was well sorted. Then lastly, subcontractors in the oil and gas industry, is there a likelihood of extending the deemed VAT regime to tier 2 contractors? I mean, this is a concern that keeps coming out at all the conferences, I think even engagements with government. This continues to come out, and I think it may not, maybe because it may not be that widespread, because now, but I can imagine players like McDermott or Zipeb or ESA, who are exclusively serving the oil companies, it would mean that they don't have any other business outside of serving the licensees or the IOCs. So any cost in relation to their operations that they get, that subject to VAT, means that they have to go to URA and seek a refund. Probably because the players are not that many, maybe URA is in a better position to manage the refunds, because if URA can easily manage the refunds in that regard, then even if you don't change the law, it may not be such a big issue. But if there are challenges around the refunds, I've not had interaction with the major subcontractors, on that issue, but it doesn't seem like it's likely to be extended or changed anytime sooner. I think that's all I can say. Thanks.
Thank you very much, Dennis. It's really been a pleasure listening to you and learning from you. And sorry, we have some feedback. Okay, and thank you for highlighting the growth that has taken place in the taxation sector and in the oil and gas, right from where we started from to where we are, and sharing how we've learned and how those experiences have shaped the current fiscal regime and taxation regime. We have appreciation here from Rema, and Abalesh appreciates. We also appreciate you, Rema, for being very attentive and participatory today. And for Juma, your question has been noted, and Dennis will respond to it online. We'll quickly move on to the next session, really because we're running behind. So for our next session, we'll switch up the program a bit. Welcome with me, Mr. Bruce Musunguzi, a partner at Kampala and Associated Advocates and head and co-head of the tax practice. He holds a master's in international taxation from Georgetown University in Washington, D.C., and has over 12 years experience. He's also been recognized as a rising star by Global Chambers and Partners in 2020. He's a seasoned tax litigator with expertise in tax planning and understands the intricacies of internal tax-related issues. He also worked as a legal associate at PricewaterhouseCoopers USA and JP Morgan for 5 years, and also has experience with banking and finance practice. He's going to share with us how to effectively manage tax controversy and tax litigation. And I'm sure if you're involved in any way in tax litigation, you've not missed Bruce. He's been there in the thick of things, arguing a number of landmark cases, and you can't miss him in the tax precedents and jurisprudence in the country. Welcome, Bruce.
Thank you very much. And thank you for all of those who are listening to us. My topic today is tax controversy and tax litigation, how to manage it. I am sure many of the people in the audience are either accountants or lawyers. So I'll try and deal with both instances from the beginning of the tax process. Of course, all of us know most of this process commences with a request for information from the URA side. Following that request for information, you start to engage with the URA in terms of document exchange. Many times that process is handled by the auditors. Very few times are the lawyers involved. Of course, this being a Uganda Law Society event, we would encourage you to be involved in that process. The reason for that is very simple, is that during the process of seeking documentation, at times there's information that your client might miss out, which might be very helpful for their case, or many times there's also some information that probably they are not supposed to be sharing with the URA at a certain stage. During the process of request for information and exchange of documentation, URA then starts to understand your client's business. At that point, once they get a feel of your client's business, then the audit process actually commences. Now, during the audit process, at times they'll come up with their findings, and once in a while when they make those findings, it's important that the lawyer is also in the room at that point. The reason for having the lawyer in the room, whereas the findings are really factual findings, many of them have an implication on the law, and they are based on the law. Once you're in the room, you're able to advise correctly your client on whether or not they should pay the tax or not, or they should continue to engage with the URA. The thing about tax litigation, and there's a tax practitioner, there are instances where you'll find that in fact your client might actually be liable, but there are instances where you'll find that probably the revenue authority is wrong. So at that point there, once you're starting to engage in those meetings, then you have the opportunity to share ideas and to assist your client to find a solution. Now, the audit process most times will end up with an assessment. Once the assessment is out, you have still an option at that point to engage with the revenue authority on how to conclude the process of the assessment. What do I mean by concluding the process of the assessment? Twofold. One is that probably the information they're asking for, or that has resulted into the assessment, is information that you would have provided before or at that point when the assessment is issued. Remember, immediately after the assessment, you have the objection, and then the objection decision comes out. Before you actually lodge your objection, you can always have a meeting with the auditors, with the URA, to discuss how to resolve the tax controversy. We've had instances where we have gone to court, and the only reason the assessment was raised was because there's a document that was not provided to the URA. So at that point, we always encourage lawyers and auditors to try and get involved at that process. Now, the other thing about the assessment is that once the assessment is out, many times the clients always want us to rush to the tribunal. The challenge with that is that the tribunal has made it very clear in its past decisions that that is premature. You have to first exhaust all internal remedies. And what we mean by internal remedies is that you have to go through the objection. The other challenge that we see, and normally when the clients come directly to the lawyers, is that we prepare our objections as lawyers. Now, what do I mean by that? It means that I'll write out my objection, maybe about 5-10 pages, and deliver it to the URA. However, if that objection is not lodged in the system, the URA does not see it. And if it doesn't see it, it does not recognize it. And when you go to the tribunal, that will also be a challenge for you. So at the point of the objection, it is always important that you keep in touch with your external audit firms so that you can have those objections uploaded in the system. Once the objection is lodged after the 45 days, you then have the process where most times URA will call you in for a meeting with the objection team, which kind of is independent from the tax assessment, tax audit team. In that instance, you have the opportunity to discuss and agree with the URA. And at times we have had situations whereby assessments are vacated, assessments have been reduced. But of course, there are also instances where the URA also maintains their position in the tax assessment. Now, once the decision comes out and it's not in favor of your client, the question is what next? The thing that we normally see happening is that there's the process of ADR after the objection decision has been made. And clients, of course, are more favorable of going through the ADR process because that saves them from paying the 30%. The thing about the ADR process is that whereas it's a process that is now enshrined in our statutes, is it doesn't allow for the extension of time. So if you decide to go for ADR, at that point there, yes, your client is right to go for ADR, but you have to advise them and tell them that if they do not lodge an application within 30 days, then ADR is not going to be a reason for extension of time. What we see happening lately is that a lot of the clientele who go for ADR think it's an automatic right of extension of time. If you look at the ADR rules, they're actually very clear that that doesn't result in an extension of time. Therefore, if you don't file your application on TAT within 30 days, then your client will be out of time to challenge the objection decision. However, that doesn't mean that you shouldn't go for the ADR process. No. The ADR process is actually a vital process because in some instances we have had situations where in fact assessments have been vacated, but many times we also have instances where the assessment is actually maintained. In our tax practice, what we always advise the clients is that lodge the application in TAT as you also pursue the ADR mechanism. When you lodge the application in TAT, the challenge that the clients have is the payment of 30%. As we all know from numerous decisions, the payment of 30% is now mandatory. So you cannot avoid the payment of 30%. Of course, there are different ways of handling the issue of 30%. If you look at the tax procedure code, section 36, I think, provides clearly that you can give the commissioner a security instead of paying the 30%, especially for humongous assessments. From our experience, we have had these issues where the commissioner has accepted us to give them a bank guarantee or an insurance bond or some other form of security. That assists clients in order to proceed with the tax appeals tribunal procedure. The other thing about it is that following the recent decision of Airtel in the Supreme Court, previously what we would have is that you had a situation where if the client paid the 30%, then the 70% would not continue to accrue interest. Now you have a decision of the Supreme Court that has come out clearly to advise you that if you pay the 30%, the 70% continues to accrue interest. Therefore, as we head to the Tax Appeals Tribunal, we also have to be mindful that the client's liability might continue to rise. Of course, now there's a limit on how much the interest can go. It cannot go past the principal, but this is something that the clients have to bear in mind. The other thing about it is that what decisions can I actually take to the Tax Appeals Tribunal? At the beginning, I mentioned that many times the clients after the assessment want to rush to the Tax Appeals Tribunal, which ordinarily the Tax Appeals Tribunal might not accept. However, there are instances, for instance, where you've gotten a private letter ruling. And a private letter ruling, like you all know, that's a final decision of URA. Following that decision, and let's imagine you are not happy with the decision, does that mean that all is lost? No, you still have an opportunity to challenge that, like we did in the Sadolin case, and that went to judicial review without necessarily going to the Tax Appeals Tribunal. So there are going to be instances where you don't necessarily have an assessment and you can't go through an objection and an objection decision, and in which case you might end up challenging maybe through judicial review. However, once you decide to go to the Tax Appeals Tribunal, like we have mentioned, one, please remember there's a 30% charge that has to be paid. Number two is that you have to remember that even the 70% that hasn't been paid will continue to accrue interest. So let's now go through the process of the Tax Appeals Tribunal. The Tax Appeals Tribunal is commenced by an application, which is a standard format documentation, where you give all of the reasons for why you're challenging the decision of the URA. Following that, then you have, after you've filed your application, the URA makes a response, then you can start calling witnesses. Now, I want to step back a little bit before you go to the witnesses. When you're filing the objection, we see this a number of times, that many times the objections don't come with sufficient evidence. If you look at the Tax Procedure Code Act, it actually says that if you file your objection, it should come with sufficient evidence. Now, that evidence should be there at the objection stage so that when you get to TAT, you don't start fighting over whether some documentation can be accepted or not. So at the point of the tribunal, you're basically carrying on the objection that you filed with the URA, but also the evidence that was included. The other thing that we need to mention is that even as tax practitioners, the rules of evidence that would apply to the High Court will definitely apply to the Tax Appeals Tribunal. Of course, we see that the Tax Appeals Tribunal does not try to be as formal as the court process. However, when it comes to documentation, we always have to ensure that either those documents are exhibited. If they are not exhibited and they are identified, we have to call witnesses who can have those documents exhibited. The challenge with not having these documents exhibited, like you will also face if you're in the High Court, is that that evidence will not be relied upon. The evidence that has come through identification will be discarded, and many times it could be very vital evidence. The other thing about practicing in the Tax Appeals Tribunal, and now we'll step to the issue of the calling of the witnesses. In the Tax Appeals Tribunal, of course, now they have adopted the system of going by witness statements, which is a very good system. And the tribunal, unlike the High Court, which would allow you to ask wide questions during cross-examination, is very limited in the amount of questioning that you can have. So it's very important that you have exhaustive statements so that at the point of cross-examination, most of the evidence that you wanted in has already been tendered in, and not hope that you'll bring this in re-examination. Of course, after you're done with that entire process, you have the decision of the court. The question is, then what next? Many times after the tribunal decision, whether it is if it is for you, then it will be the URA that is going to appeal. If it is against you, then it is now your side to appeal, lodge your application for appeal. When you lodge your appeal, some of the things that you need to really consider, of course, now we have the right of appeal between TAT and the High Court, but one of the things that you need to consider is applying for the stays. Because remember, at the beginning, we talked about the payment of the 30%. But remember, there's still the 70%. Most times, once the decision is issued, URA will rush to issue the agency notices. It's important that at that point, you've already obtained your stay. But remember, at the High Court, the conditions for stay are different for the conditions for the injunction at the lower court. So it's important that you also provide security, maybe at that point, for payment of the balance, so that these stays are granted. So that is generally the process of handling a tax controversy and tax litigation. I hope I have summarized it well in the short time I was given, unless there are any questions or any points that you needed me to clarify upon.
Thank you very much, Bruce. That was really summarized, but I think it touched all the points. And really, thank you for that, emphasizing the need for collaboration and the need for engagement by the lawyers. I think yesterday, with our first presenter, the presentation was on the role of lawyers in tax compliance, and it really highlighted those areas where lawyers play a role in supporting their clients to be compliant. And one of them, like you mentioned today, is being there in those initial stages, document exchange, what documents should you provide, what information should you provide. It really does help in enhancing compliance, but also handling any controversies that might arise early. You also mentioned working with the auditors. That's also key, especially since these are tax matters, and you might need their perspective as well on what information and what issues to consider. And also highlighted the mode of filing these objections with URA. I think that's also key because, like you noted, it's usually a source of controversy where someone says, I wrote a letter and we're arguing whether there's an objection or no objection, and the tribunal has really ruled on that as well. Thank you for highlighting the timelines and how that ADR process does not affect provide an extension of time to that. I think that's also an issue that's been coming through a lot, how people would prefer to go to ADR, but there's no extension on time on that. So we will have to be mindful of that, and the payment of 30%, of course, at the tribunal, and the processes of the tribunal. Now, I think that pretty much summarizes this. Online, participants at this point, if you do have any questions or issues that you'd need clarification on, this is the time. We have one comment from Rema, again saying brilliant, thank you. I see Edmond Agaba, if you have any questions, to kindly unmute or send a text to the panel. Or it could be that Bruce has done an excellent job and we don't have any questions. Okay, so we have one question here.
Thank you, Prida. And mine, firstly, is to commend Bruce. Bruce has been very commendable in our space and in our cluster. Yeah, Bruce is one of those people who often share cases. Every time his firm handles very many cases, but every time his firm handles a case, he's very happy to share. Whether he handled it or he chanced upon it somewhere, he's very happy to share. Considering decisions in our space are very rare to get. If you go to Uli, they're hardly there. So Bruce, by all his means, he somehow gets his decision. So Bruce, we commend you for that. And I think for me, mine was just, it's also a question or guidance, or how would you advise the lawyers in this space to access tax decisions? Because TAT channels out very many, High Court channels out very many, but where can the young lawyer out those ends is venturing into this space? What can they do? What are you doing different that our people are not doing? Yeah, and what can they take home? Because the decisions definitely shape the jurisprudence and court interpretation, which is very important. So over to you, Bruce. Thank you.
Okay, thank you, both of you. I will start with your question and then end with Prida's comment. Access to decisions. Yes, you're right. There are a couple of decisions out there. There are High Court decisions, tribunal decisions, Supreme Court and the rest of it. Unfortunately for us is that many of them are not being uploaded. For the young lawyers out there, we always encourage you, visit the tribunal. It doesn't hurt. Even at my stage, I still go to the tribunal to look for these decisions. Yesterday was a decision of Easy Supermarket. It's out now. It's always encouraging for us to go and visit these courts and tribunals and ask them for their cases. The good thing now is that these documentations are available to the public, so it is not that somebody is doing you a favor to give you a decision of court. But I also encourage you to look outside the jurisdiction of Uganda. A lot of jurisprudence from Kenya has a direct effect on what happens in Uganda, especially because our tax statutes are pretty much the same. So it's very, very important that you look at both the Kenya High Court, Kenya Tax Appeals Tribunal, Tanzania cases. Those we have found to be particularly relevant to our system here. In addition to that, always visit online. I see a couple of decisions from the UK. Of course, the challenge is that the UK and the Indian tax regimes are not pretty much on all fours with our tax regime. So once in a while, you land on one that has a relevant principle, many times not so much. But just look at them because they at least help you understand better the philosophy and the reasoning behind some of those tax provisions. So in terms of access to material, yeah, the courts are our best source of this, and would always encourage the young lawyers, try as much as possible to go out there and pick those decisions. If you can't get the decision and you need it, kindly get in touch with us. Like with the panelists have said, if you go to the ULS WhatsApp portal, we are always available to share with you those decisions. On the issue of request for information, it's one of those issues I normally see lawyers playing hard to get when URA asks for information. Yes, at times there's information you might not want to share, but you know, under the law, URA is entitled to this information. And if you refuse to give that information, then your client could end up being penalized. So these are some of the things that we need to really think about. The other thing to think about deeply is that whereas you think that information might be incriminating your client, many times you could find that that information, if explained well, would actually assist your client. Therefore, rather than having your client charged for not giving a document, which document they are going to ultimately get, it is always encouraging that let's share the information and explain it better. I think the challenge that we have is that we just dump onto URA 1,000 documents with no explanation. And we hope for some reason they are magicians and they are going to understand our case. They won't. Same thing with the tribunal. If you dumped onto them 1,000 documents without explaining anything, they won't understand your case. So for us, we would always encourage you, once they ask for the information, give it. But also for the young lawyer out there, timelines, please don't play around with the timelines. I am yet to see a decision of the court where they're extending time for late filing of an application. To the best of my knowledge, there are probably about 2 of them, one of which dealt with the COVID situation. So I don't play around with the time. Make sure you file those documents on time so that your client's case is heard. Thank you.
Thank you very much, Bruce. And there's lots of comments appreciating your presentation. Well, in case of any other comments, questions, we'll take them in the Q&A session. Thank you very much.
Thank you.
All right, well, it's afternoon already, 12, and we'll go right into our next session. The next session is tax planning for high net worth individuals and estate planning. To present this is Augustine Chigundu, a partner tax at Otis Advocates. He's a lawyer and tax consultant with special interest in tax advisory and litigation services. He has over 9 years experience providing tax services, specifically tax compliance reviews, tax advisory services, and tax authority audit. He's previously worked at Ernst & Young and KPMG. Thank you very much for joining us today, and you can take it away.
Thank you very much, Prida, for that not so humble introduction, but in the interest of time, I will oblige. Colleagues, I think it's important to note right from the onset, and I think for the benefit of our colleagues that do not interface with matters tax very frequently. When we talk about the concept of taxation of high net worth individuals, we are not, please don't run to the Income Tax Act and start looking for a specific chapter or part that deals with taxation of high net worth individuals. You will not find it there. High net worth individuals are of particular interest to the tax administration because, well, first of all, from the economic perspective, they have an abundance of two key factors of production, which is they have an abundance of capital, and then they have access to land, which from an economic policy perspective, they make that category of persons an interest. Then from a tax policy perspective, there is belief that if you bring these high net worth individuals within the tax net, it's very easy to collect so much money. You can imagine if you had just two billionaires, say, remitting 200 million Uganda shillings, as opposed to chasing 200,000 people on the streets just to collect half of that. So it's important. That's why this particular category of persons is very important for purposes of our analysis. Now, who are high net worth individuals? And it's important. Some jurisdictions have defined them. For example, I see here South Africa, according to the tax administration, anybody that has gross income of at least 7 million rand. When you go to Australia, they have a threshold of about net worth of 1 million shillings held in various portfolios. It's important to note in Uganda specifically, we do not have a threshold. But I think it was around 2013, 2014, URS started quoting this category of persons. You would see this in their publications. They're talking about high net worth individuals. So, of course, the interest there being, who are these people, in effect? You look at a list of large taxpayers, most of these are corporations. But in there you see one or two persons there, individuals, and you're wondering, are these the high net worth individuals? But we also know for a fact that very many of these wealthy people are operating under the radar, so they may not actually be visible to the tax authority. Then I think around 2015, still URA is introducing another category called VIP group. This VIP group, if you're looking at their publications, you're looking at the president, those political high-ranking political figures. Then we also started looking at persons, for example, heads of institutions, looking at banks, then also looking at key investors. But the sum total in all this is they're trying to create a category of persons from whom, if you brought within the tax net, you're in position to collect so much tax. But I also need to note, for purposes of, I didn't want to bastardize my presentation. For purposes of this presentation, high net worth individuals, we'll look at it literally. So here we look at the economic elite, the affluent, what we normally call the big boys. It could be yourself as a member. So just for purposes of this presentation, we'll just look at the literal approach to high net worth individuals. Now, we also have some statistics in there, the criteria that URA has been using. For example, we're looking at shares. A number of people have are directors in so many of these large taxpayers. They're also looking at commercial buildings, land. That these presentations will be shared with the team, and you could have a look at that. Now, very importantly, and specifically, yes, we may have on our personal level a criteria we use to identify these high net worth individuals, but from a tax perspective, there are certain informal parameters that if you're seeing yourself bending towards these parameters, then chances are high that you could be categorized as one of those high net worth. I had an experience. I had one of my clients wanted a tax clearance. When you looked at their returns, they were filing very modest returns. Say I only make 2 million a year, but under their TIN they had over 20 motor vehicles, and with lots of activity on their mail portal. Say he has transferred this to this person. So it later turns out that this individual was actually informally a money lender. He was also dealing in motor vehicles. By the end of that whole exercise, this individual was actually a medium taxpayer. So by just looking at some of those informal parameters, the tax administration can be able to identify you as a high net worth individual. Uganda being largely governed under the real economy, ownership of land is another parameter that would certainly solicit interest in your dealings. A lot of people that have wealth want to plow it into real property. They want to set up buildings, they want to buy land, agriculture. So ownership of land in its own self, and the more transactions that you get into would potentially drive you into that category. So you could be home sleeping, before you know it, you receive an email and you're one of the largest taxpayers, all because they're just tracking the movement around that. We have farmers. We know farmers that have vast lands on which they're carrying out either for commercial purposes or even just leisure. Those are people that are within the watch of the tax administration. Then there are also issues around rental income. As you're aware, for some of us who practice tax, there's now a requirement for just simple administration. You can't file an income tax return where you disclose a rental payment without declaring the details of a landlord. So from the back end, the tax administration is able to see so much rental income that is coming from this particular individual. And for those purposes of planning, you find that lots of people actually, I think some of you may have gotten a few clients here and there, receiving assessments saying, but we're seeing third-party information, you are earning so much money in rental income, but when you look at your return, we're only seeing moderate declarations. And we've had instances where people are actually being asked to foot a huge and commendable size of the tax bill. Then we also have these cars as well. Some people even have personalized number plates. I had an instance where a lady had airlifted, I think, was it a Jeep? Upon reaching customs in Entebbe, clears the taxes, then at the point of release, the vehicle was seized and were issued a letter, an income tax assessment, saying, when we looked at your tax dealings, we don't see any income. You're not employed anywhere, so we're wondering, where did you get the money to buy this very expensive car? Not even ship it, but airlift it. At that time, I remember receiving that phone call, and the big question, of course, for me was, yes, there were some valid concerns there. Where was this money coming from? But because I also wanted to retain the client, I couldn't ask those hard questions. And later I'll speak to source of income as a key parameter for high net worth individuals. So Just to speak very briefly around the challenges around taxation of high net worth individuals. Now, I will tell you for free that URA is very intentional about high net worth individuals. In fact, they even have a strategy around getting these high net worth individuals within the tax net. But they're also mindful of the challenges that high net worth individuals possess. For example, we know since they have access to a lot of money, they could potentially hire tax advisors like ourselves to just assist them in ways within which to plan their affairs. Then there are also challenges around, because they do have this money, they could potentially disguise transactions. In certain transactions, they even disguise privity. You've had instances where individuals are transacting, but through proxies. Someone owns a vast chunk of land, but his name will never appear anywhere. So the tax authorities is well aware of all these avenues, and there's a strategy to try and dig out all these issues. Now, the other aspect is, yes, we do have professionals like ourselves and very modest incomes, but we are able to accumulate a lot of wealth through these loopholes, the informal setups. You find an associate earning just $1 million shillings, but has a fleet of over 10 taxis and say 15 borders, each bringing him say 50,000 a day, informally. So to the tax administration, all they are seeing is the 1 million this person earns a month, but informally this person is able to earn so much money that the Revenue Authority may not be able to see. And that also speaks then into the next concern around the influence. Because these high net worth individuals have access to quite huge sums of money, they can always influence some of these decision makers if they are not actually the decision makers themselves. So if they are not the decision maker, then they have access to these decision makers. We find civil servants with modest wages, but they've accumulated wealth in terms that you could not even explain. Then we also have those that get into even more aggressive tax planning avenues. You find them setting up offshore entities, and then they're rerouting payments to them through tax havens, probably areas where we have jurisdictions where we have double tax treaties, and this is where they're rerouting their payments. They have an offshore shell there being run by a management company, and then payments actually coming through. So all these challenges that the tax administration is fully aware. Now, if you look at specifically what, if you look at, for example, the avenues or strategies that the Revenue Authority is deploying, we'll start from just simple things. I've already mentioned, for example, from rental tax. Even simple administration, you can't file a return without declaring details of a landlord. So in that case, you're able to, one, increase traceability and also visibility around these high net worth individuals. There are also initiatives, for example, like the taxpayer expansion projects. You create one-stop business centers where someone who is going for a trading license would be required to first register with URA, and then before you proceed with all these other avenues. Then we've also had the rental project Riponami, I think, something like that. Riponami, that project that was aimed at trying to using GPS systems to try and map out all these buildings, just to make sure that everybody that owns the structure from which rent is derived is paying a fair piece of their cake. Then there's also those interdepartmental collaborations. We could be advising our clients, telling them, okay, please, you could disguise your out. But with National Water, this same person has 10 water meters to their name. So the question is, do you really live in all these 10 houses? So with this information sharing, definitely these high net worth individuals are more or less most likely to be caught under some of these initiatives. Now, very important still with URA, we've seen initiatives, for example, the e-tax. Now with the e-tax, URA from the back end is able to understand who is trading with who by just simple declarations that we put in our tax returns. These are all avenues that are aimed at bringing all these people on board. Then not very prominent, we are seeing the tracing of consumption habits. And I know some of you may have had instances where some of your clients have been asked questions. I just gave an example of where someone was asking for, you're seeing a lady has no income whatsoever, but then they're driving the Porsche cars. So those questions are actually on the increase. And that brings me to the discussion around source of income. I normally joke around with my colleagues from URA who like to front this source of income thing. I'm very interested. Where did you get the money? And people make money in very many ways. Some of the ways in which people make money, they're not even proud of some of those ways. So as tax policy or as a strategy, what should be the goal? Should we look at source of income? Say yes, source of income, or should we look at traceability of where that income is being deployed? And as a cluster, I think this is where we need to come in and help the tax policy framers here, very importantly. Because, for example, you can imagine if someone appropriated just 2 inches of asphalt along a 50-kilometer road. I remember the president at some point was under fire from these political commentators when he advised the IGG to go slow on some of these corrupt people, because they could easily take the money outside Uganda as opposed to investing it within the country. So from a tax administrative perspective, it's very important. For example, if you're able to land on a huge bulk of money that has landed on someone's account, do you want to go and tax that? What if, as you're still negotiating, the IGG comes up with an investigation that actually realizes that this money was just stolen, and they want it refunded? Do we then go back to the tax administration and say, please refund the 30% that you took for this source of income? Or so those are questions that we as a cluster need to help the tax policy framers, mainly around the source of income. Now, from a tax planning perspective, it's important to look at where investments are being placed, and key to note around, for example, for a capital perspective, the two main taxation points there being at the point of accumulation of capital and or at the point of reward. So if you pay the dividend on your capital stock, then the taxman is very interested in obtaining at least a tax on that dividend. Then when you get to the land rental income, and all these initiatives that are being fronted, try to identify, trace all these individuals that have properties that are earning rental income, and then just to make sure that they pay. Interestingly, I was having a discussion around people that were worried about these revisions of the tax rates on rental. And I was telling them sometimes it could be a government strategy. You lower the rental tax rates so that these high net worth individuals believe that because you're paying so little nominal. For example, currently the rate is just 12%. If I was government, I would actually reduce it to just 5% for a period of just about 2 years. You have all these people getting excited saying, can you imagine government is only taxing us at 5%? They get within the visibility bracket, then 2 years later push it to 30%, just like the companies do. It could be a strategy that could work for government. Then at the point of disposal as well, capital gains tax, it's one of those that is picking up steam. If any of you has been behind any transaction, you probably receive an email from the tax administration around whether there is any gain that is made on that transaction. Then as well, worldwide income, we had presentations yesterday that guided on this very important aspect. So many of these high net worth individuals are receiving incomes from overseas, and they're not declaring these. But the tax policy is you should be taxed as a resident on all your worldwide income. So these are all avenues that as advisors we need to be very mindful and very keen in terms of how we deal with this. So as already indicated, distribution of dividends, there will be a tax at that point. So it's important for us as we're advising these individuals that are receiving, that have invested quite a significant amount of stock in dividends. At the point of payments, there will be those tax considerations. In terms of rental, yes, we've already identified that there is already a rental tax, which is 12%. Some of the commercial properties could potentially be vatable. From a planning perspective, it's important to always keep records. We've had instances where our friends from the tax administration always say we have third-party information that you're earning so much, and most of the people fail to rebut those assessments because they do not have proper records. Then the frequent buying and selling, the reason being is these normally these are trigger taxes at the points of purchase and selling. So as a strategy, look at actually consider holding onto properties for longer periods of time. Diversification, here now we get into aspects around analysis of investments. Do you go into investments that offer high taxable income, or vehicles that may not offer high taxable income, but then they offer a return, but which is subject to a lower or no tax at all? So here we give an example, for example, investment in unit trust or share stock. Now, around capital gains tax, this is normally triggered at the point of disposal of assets. Key to note there is ensure that all the costs that you incurred are well documented. If you paid some lawyers for advice around your transaction, it's important that you document all those things, because they do form a basis upon which your capital gains tax, purported capital gains tax, could be reduced. Very quickly around income from abroad, as we already noted, the policy or the tax considerations here being that Ugandan residents are taxed on their worldwide income. So a lot of these high net worth individuals have investments in portfolios outside the country, and to them these are normally not considered taxable. And we've had instances where, for example, people that are exporting trade, you had an instance where someone attempted to collect tax from someone who was returning. Say, but me, I was out of the country. All the income I was earning was not from Ugandan sources. And the issue was, are you a Ugandan resident? Yes, please. This is income that should be taxed in Uganda. So take advantage of avenues like the foreign tax credits. Also understand, for example, the double taxation treaties. I know currently the challenges around the beneficial ownership, but over and above just the double taxation relief, there are issues to do with stability around investments. So it's important to understand the context within which a double taxation treaty was reached, and whether there are any advantages that can be taken care of out of that. Then very quickly around estate planning, colleagues, you'll bear with me that estate planning is not a very popular concept in our world. I don't know what your experience is around, for example, administering of estates. I'll tell you, you'll find examples of a matriarch or a patriarch who left his children a 10-acre, prime 10-acre piece of land. You have 2 children from one camp, you have another 2 children from another camp, you have another 3 children from another camp. Immediately they talk to their lawyer around how to deal with this. Till you're entitled to this portion of this estate, all they're interested in is give me my share, and that's all. I don't want anything to do with that camp. I don't even want to see children of that. These are the discussions that we normally have. There may not be issues around tax. These are mainly around perceptions, attitudes around our people. But this realm of estate planning is very unpopular. I was looking at a statistic from Stanbic Bank. They said in Africa, just 15% of persons have actually undergone this process of planning for their estates. In Uganda, I bet we even exceed 1%. It's a very unpopular scenario. People are always interested in just give me my share and I'm done with that business. But if you look at avenues, for example, I sit as a company secretary in one of the very prominent family-owned businesses. You look at how they structured their avenue, right from the first generation that conceived the idea of setting up a very prominent school. Now, reach out to a friend, leases them 4 acres. Then the first generation brings on board the second generation. Second generation, they widen their scope. Now they have a 10-acre plot of land. Second generation now invites third generation into management of this school. Currently, they have 2 campuses. Next week, they have an AGM quoting the idea of declaring a dividend of over 2 billion shillings. When you're looking through that story, you're imagining what if the first generation had not gone ahead with such initiatives, and like I said, you can't really blame this on tax. These are largely around perceptions of people, but I believe personally that tax through policy can be used as that step to helping people at least achieve what they need to achieve. So estate planning ideally is just looking at 3 things: protection of wealth, preservation, and then growth of wealth, and what normally they call wealth management. And there are various structures within which we can get into these avenues. We have just listed a few of them, but and these are known to us. But I think for us as a cluster and where I employ our colleagues, I think we have our work cut out for us around the realm of estate planning. If I own, for example, the example I gave of this 10-acre plot of land, what tax policy initiatives are there for me? For example, if I wanted to set up a special purpose vehicle, say a school in this case, the land is in my name, but I want to set up a school that will generate incomes for future generations, for my future generations. What tax policy initiatives can be put in place to help me achieve that? For example, currently, if I was to transfer that land to that special purpose vehicle, there would be all these taxes that would come up, stamp duty, all those things. But I think for us as a cluster, we owe this to the tax policy people. We need to let them know that some of these initiatives are good initiatives, and we should have, for example, I wouldn't mind incentivizing people that do some sort of planning around that. For example, if you're transferring land to a special purpose vehicle just for purposes of preserving your estate, you should be able to incentivize that. I know the private sector foundation is pushing for that as well. They're trying to push for initiatives that will see Uganda turn out to be a favorable domiciliation for private equity funds. I know IAVCA, the East African Association of Venture Capitalists, is also pushing for that as well, and Stanbic Bank as well. I know some of our colleagues here have also participated in that conversation. So my takeaway from this is, as a cluster, I think we need to keep the conversation running. We need to find ways in which we can incentivize these structures around estate planning. They are known. The other day we had conversations around the taxation of collective investment schemes and what that means to issues like estate planning. So I think for me, the takeaway is, let's keep the conversation running. As a cluster, I think we have some work to do just to make sure that we have all these avenues straight line, so that people do not have to, get into those things of this camp does not want to deal with that camp. For me, give me my share. Even before you get the instruments of ownership, someone has already transferred their portion just because they don't want to deal with that family. And you may even find in some of these instances, the families, we're talking of very prominent people. You have 2 lawyers, 2 doctors who can actually mobilize capital just to push these ventures forward to further generations. So I think that's within a very limited time I was given, just a quick nutshell around taxation of high net individuals and estate planning. I thank you.
Thank you very much, Augustine. That was a mouthful, but really covered the areas of estate planning and why the interest in high net worth individuals and what factors to consider. Just to say, when you said that there is no special tax for high net worth individuals in the law, that's indeed true. There are no special taxes for them, but like you mentioned, it's a peculiar group with lots of resources, and if we are to have a fair tax system and equity around it, it's only fair that everyone gets to pay their fair share, because at least we're alive to the cry sometimes that the few bear the tax burden, while because of the informality and all others get away with it. So thank you very much. It was indeed insightful, and really laid out some pointers of which areas to consider and which areas to work on, as well as some action points for the tax cluster. We have a number of comments I'll read too, and questions. From Ian Mutiwa, he asks, can you please speak on indexation for CGT? I think that's capital gains. And another one is from Moses Lugaizi. Thank you for the insightful presentation. Says this might sound funny, but it is happening. So I think it's a comment. For the criteria used for selecting high net worth individuals, have seen your go into the Ascrida system to see if any or some imports, if anyone, I think, imports a vehicle worth 100 million and above, and those that own commuter taxis. For high net worth individual that has high commuter taxis, Yuri has gone impractical to an extent of estimating tax depending on the amount of income that the taxis bring in on daily without factoring the expenses the individuals face. For example, repairs, PSV costs, KCA costs. Would it be advisable to tax this part of income under the presumptive tax regime because of the improper record keeping and the annual revenue and doesn't exceed 150 million? Let me know your thoughts.
Okay, thank you very much. Ian, a request for just a quick high-level review around indexation. Indexation is provided for to cater for changes that arise out of the cost base of an asset due to inflation. And indexation uses what they call the consumer price index. So if you acquire an asset, for example, in 1996, for say 100,000, I don't know what the dollar rate was in 1996. Would say some people that have that were very active in, so we'll say 800 shillings. Oh, someone has told. Some people have been here. Yeah. So and you're selling an asset, say today, at 300 million. Now, 300 million, the dollar rate now is 37.50. Now, and the tax law gives us a very simple formula for capital gains tax. For us to determine the capital gain, first of all, we determine your sales proceeds versus the cost that you incurred. In this scenario, we have a cost of just 100,000. The selling proceeds here, 300 million. What that means, you could potentially be facing a capital gains tax of a gain of over 290 plus million. But the reality on ground is there has been change in the value of our shilling. And the key factor here to note is just look at the dollar rate. Yeah, so indexation comes in using those consumer price indices to try and map up this cost. For example, this 1996 cost, the hypothetical 100,000, to map it up. So what is the cost of the 100,000 cost in today's terms? What is that cost in today's term using the consumer price indices? So that's where the indexation comes in from. These indices are provided by Bank of Uganda, and there's a formula that we follow in the Act, but the essence of that is just to try and map up that cost so that it mirrors what it would have been in the current situation. Then they also asked for my thoughts around URA raising assessments based on information they get from their own systems. Like I already mentioned, these are all initiatives that are being used by the tax administration to trap a highly elusive category of persons. Here we've called them high net worth individuals, but even ourselves, they may not even be high net worth individuals, but there are people that are getting into transactions that you may not even explain yourself. And using those consumption patterns, you could throw it to them. And first, it could be a starting point. Just throw it to them, engage them into a discussion. Before you know it, I gave an example of the gentleman that ended up being a medium taxpayer by just going for a tax clearance. Before you know it, when you analyze his transactions, you realize that actually this is a gentleman that was not being forthright with his declarations to the tax authority. So yes, as a starting point, these consumption patterns, your transactional history, it's very important that URA uses that as an initial gateway into your tax dealings. So yes, those are already there, and I think it's one of the ways in which the tax administration can push up their collections. Thank you.
Thank you very much, Augustine. And I think the other key issue to note from your presentation is, especially around information, is in this digital era and globalization and all, the access to information is much more easier. So in terms of URA using this information to sort of profile the taxpayers, it should be expected. But to the lawyers and to the taxpayers, it goes to say there's more visibility now, and the wiser thing might be to either declare voluntarily or run the risk of URA finding it out and characterizing it as it deems fit. Because I think in earlier presentations we talked about the Exchange of Information Act. There is all this collaboration with different entities, even for income source from abroad. Maybe the other issue was the issue of source of income again, when you talked about the money was stolen and it's now been taxed and IGG now wants it refunded. I think we have an interesting ruling from the Tax Appeals Tribunal around that, where the chairman says really for purposes of taxation, it does not matter whether the money was obtained illegally or legally, it's income and it will be taxed. So I think that would be a key. It may not be an issue to consider for the taxpayer really to say, but this was stolen money, how do I pay tax on it? So yeah, but those are the considerations really. going to this. Thank you very much, Augustine, and thank you so much for the participants. I note we still a full house. I see Rachel Faith is still online. Thank you, Nampija. Sophie, you've been in since yesterday. And I see many more. Mr. Nerima is online. Rema is still online. Thank you, and we appreciate. Keep the questions coming. Keep it interactive, and let's enjoy and learn from each other. So moving along, we'll have final presentation for the day before we go into Q&A and closure. Welcome with me, Michael Chibuka, to present managing the tax function. Michael Chibuka is a fellow member of the Association of Chartered Certified Accountants, FCCA, and he's currently a tax manager at McDermott. He has experience in accounting, tax advisory, and tax planning, and we welcome you to share with us this afternoon.
Thank you. Good afternoon to everyone listening in, and thank you first of all to the Uganda Law Society for organizing this event. I think from the sessions we had yesterday and for the people we have listened to today, it's been really insightful, and we've learned a lot. And I'm also humbled to be one of the people going to speak to the distinguished colleagues on the call and everyone listening. So it's humbling that I get the chance to speak last after many more senior colleagues. And thank you also to BDO for hosting us and for supporting the Uganda Law Society in doing this. I've been asked to talk about how managing the tax function from the trenches. First, let me start with a disclaimer. The things I'm going to say are my personal opinion. It's not a representation of the opinions of my current employer. And when you see any images in the presentation, they are only for education purposes. So the copyright owner of the image may have not infringed. I think education purposes like this event is permitted use. It's good I have the Law Society behind me. They'll guide and also support. Maybe I was asked to talk about quite a few things. As a large taxpayer, what are some of the challenges and solutions that we face? What are the challenges of managing a corporate tax function, and what are some of the strategies for ensuring compliance and minimizing risks, the use of technology, and the thing that most people, the lawyers on the call, want to understand is what does a client expect from a lawyer. I've also put in some few personal comments based on the discussion that has been going on, so that we can conclude this well. Now, to dive straight into it, I would like to first of all talk about the things that we have had: tax avoidance and tax evasion and tax planning. And we have said it a lot, but I just want to add my voice to the same. Tax avoidance is not illegal. It's something basic. I plan my affairs in such a way that I minimize the tax that I am supposed to pay. You know, tax is not voluntary, that you pay when you want. It's a creature of statute. You just have to oblige to it. So if there is in that statute ways of how I can minimize the tax I have to pay, I do take advantage of it. I will give just a very common example of where tax planning or tax avoidance takes place for people to bring this home. Now, I could decide if I'm investing in a business, do I give it a loan so that they pay me back interest, or do I put in equity capital and they pay me back a dividend? The decision on what to do is tax planning, tax avoidance. I'll just give an example. If I am to give a loan, I can get back interest even when the business is loss making. Okay, that interest expense is a deduction to the corporate income tax of the entity. Now, on the flip side, when you look at the other side, for dividends, we have a bad law for stamp duty, just my opinion. Why would we tax capital? So if I'm investing capital in a business, for example, I'll pay stamp duty on my investment. I don't know if other people have the same sentiments, but I think it's a bad law. It should be just a nominal registration fee. Now, and also, when it comes to capital, it can only be paid out of a dividend. So if the business is not projected to make profit in the next 4, 5, 10 years, and we know, for example, the business most people invest in is construction or real estate, it takes at least 10 years for you to make profit. Let me give an example of, we all know, we have heard that the Aya Hotel, the Pearl of Africa, is going to be liquidated. Now, if he had put in a loan, he's one of the people entitled to get money back. But if you're putting capital, it's gone. So tax planning is that simple. It's not something, it's okay, not that simple. You need to put in many factors and variables, but it's not as bad as maybe some people make it sound. The bad thing is tax evasion, where you deliberately don't pay or underpay taxes. For example, smuggling. And there are punishments, prosecution, imprisonment. Now, smuggling sounds like, when you talk of smuggling, people think of people on the border running on borders with jerry cans or fuel or some supermarket, something like that. But it's as simple as you going abroad and coming back with maybe 4 or 5 laptops in your suitcase. And you pass through the customs, they ask you, do you have anything to declare? You say no, and you take them home. That's smuggling. So if they actually found you, that's tax evasion. So it's just to show the distinction. Avoidance is not illegal. It's how do you plan to minimize the tax that you pay. Evasion is the illegal bit. Now, when you talk about tax planning, what I'll tell people, the best tax planning is to comply, tax compliance. That's the best, because you cannot run if you can't walk. So you start by walking, complying, then you can think of other ways of how to minimize the liability. So just wanted to say, just that's my opening remarks before I go into the discussion points. Now, large taxpayers' challenges and solutions. I've broken it down based on the things that relate to tax registration, the payments of the tax, and then, of course, dealing with the administrator, the URA. Now, when you are registering or starting up a business, for example, there are many things I thought about that I could share with the members, but I've picked out just 3 things that are usually a problem. One is for VAT. When you have just set up, you don't meet the threshold for registration, and you're already incurring expenses. The limit is 6 months before registration for no more expenses, and for manufacturers it's a year. Now the challenge is, I want to recover my input tax as early as possible. So how do I register early? So it's something to think about. It's maybe you do early invoicing to your potential clients. It's something to think really that bothers people, especially at the startup. Now, there's another thing called foreign directors. This is a big problem for multinationals, because a multinational enterprise, for example, already has employees and business in other places. So when they set up in Uganda, they usually nominate directors who are normally foreigners before they hire any Ugandan employee. Now, when you have foreign directors, to register the company for the TIN, they require the directors to also have a TIN. Now, when you have foreign directors with TINs, issues that come up. One, they have to file returns. They'll ask you, we're seeing in your pay returns there are no directors are not filing. All those around those issues. So how do you deal with such? The other issue is about withholding tax exemption. For cash flow purposes, you want to be exempt as early as possible. It helps with cash flow because cash is king, as people say. So, and URA says, for example, when you apply for exemption, or you have not made 3 years yet, or your directors are not filing returns, you have foreign directors, or the director's income is not commensurate to their lifestyle, and you find out, how do they know their lifestyle of a foreign person? So there are many issues around setting up a business that are challenging. Now, maybe possible solutions, there's no one size fits all, but maybe some of the things we've done in the past, if you have only foreign directors, when you hire some senior local employees, we give them a power of attorney to act as a director for URA purposes, and they're registered as a director contact person to try and alleviate the issues. When it comes to withholding tax exemption, if you're importing plant and machinery, you can get the exemption before you make the 3 years. So these are things like, if you talked to a practitioner who has a lot of experience, they will always find a way around it. I hinted on the second challenge, which is cash flow. Cash is king. One of the things when you talk to many of the people is VAT and the payout. So you invoice someone today, the payment terms usually not few businesses, but most people have what you call credit terms. So you invoice me today, I pay you after 30 days, but the tax is due in 15 days. And now sometimes you don't have the money to pay out. I'll give an example. In the industry where I work, you will find a company getting a contract maybe of $4-5 million, and it's the biggest they have had in their entire existence. They have not dealt in such monies before. They have maybe also thin cash-wise because they're investing in training their employees, getting certification, buying equipment. So you invoice maybe the advance payment of $500,000, and you have to pay tax on that. Now, the contract says you'll be paid maybe in 45 days. You are saying you need the cash in 15 days. So how do you deal with that? So it's one of the things I can see. The other issue is withholding tax timing on two sides. For example, using the same example, 45 days payment terms. You invoice me today, and you give me an IFRS invoice. So when do I pay the withholding tax to the URA? We know the act says paid. Paid is accrued, paid or payable. Now there's things to do with dividends. I can declare a dividend today, but maybe I will not pay it in the future. The law is clear on it. When you accrue, that's when you pay it. Now, with payments and cash flow, there's like I said, there's no one size fits all. There are many possible solutions. If you speak to your consultant or someone, they'll give you ideas on how to do it. Things may be, for example, one of the things that you could do, for example, for loans, people take out loans and there's interest that is accrued. Now, so the issue is put it in the contract that the interest will be accrued maybe for 4 or 5 years, but it will be paid out in the last year. So it's clear that maybe that the withholding tax will be tagged instead of to the accrual to the actual payment. So these are some of the small nuances that you can think about. Now, talking about URA, I've called it a puzzle, but it's a bit sensitive because we deal with them all the time. So you need not to say bad things about them. So because sometimes they can come and bite you. But just dealing with the URA, you need a TCC, for example, to get work permits. You need to go to the URA. Sometimes there's assessments. Even the most of compliant people, you submit a return maybe for VAT refund. Someone looks at it, says, these guys are buying sugar, they're buying so much sugar, maybe it's for home use, they disallow it. It's saying maybe it's a refreshment, but you're buying it for office use. So sometimes the things that the URA does, like assessments, you need to find a way of dealing with them. I'll not say much about ledgers. Yesterday we had the discussion about K files. Senior colleague Kefas did it justice, so I'll not say much more about the ledgers. URA still just put it in three categories. What are the challenges? One is the policy changes. Now, in the past, if you got an objection and you felt that there was something grossly wrong with the objection decision, you would actually go to the URA and ask them to review their objection decision, and they were obliged. And if it was obvious, they would actually change it. Now, before you know it, it's a practice we're used to it. If I see a bad maybe objection decision, I can go to the URA, ask them to review the objection decision. But lo and behold, you hear there's a third ruling that GEM, who followed the same practice, GEM discount stores, when they went to TAT after the review of the objection decision had been rejected, they said they were out of time. Now, when you think about it, I've been talking to you, the URA. We have been having correspondences asking me for more information. You actually respond to me. So you say, oh, that was not within the law, which is actually right. It's not within the law. But why are we doing it in the first place? So now it's very clear. So if you are used to doing things in the old way, just to use the analogy of Senior Kefas yesterday, it's like a traffic light in Uganda. The lights are red, but the traffic man is telling you to come, or it's green and someone is stopping you, the borders are crossing. So but we don't stay at home. So you drive, you get used to it. So you adjust. You look at the lights, look at the traffic man, is he calling you? Watch out for the borders as well. So it's, with policy and the URA, you need to be vigilant. The other thing I wanted to talk about is the reverse VAT payment. There has been no change in the law. In the past, imported service VAT, if I hadn't put VAT, I wouldn't pay it. No change in the law. You already changes the template now. For every imported service VAT, separate PRN. Okay? What's the basis? Just change of heart. So we need to move with the times. Has anyone challenged it yet? No. Is it something the Uganda Law Society can pick up? I think they should look into it. And no one explains why it's happening. Maybe possibly they'll change the law in the future as well. When you think about that reverse VAT, like in 2011, 2012, you used to call it reverse VAT. There was a regulation for it. You do your invoice input, output. They changed it the same way. Afterwards, the law has changed. So we need to always be vigilant when you're dealing with the URA. Now, there was a long discussion about URA implementing the rulings, all changing laws. Right now, the elephant in the room is the ledgers. The tax has been waived. I want to look at my ledger and see what is my principal tax, what is the potential interest that would be waived. If my outstanding is only the principal, do I actually have to do anything about it, or you are automatically waive the interest and my ledger is clean? We don't know. Can you push them? Can you do anything about it? Yeah, just something to think about. When you talk about the tools as well for the URA, like the if risk credit notes, who approves them? What's the criteria for those that come to you to approve? There's a time it was totally blocked. So think of input VAT claims. They say in the law it's clear 6 months. When you try and put a 6-month FDN into the VAT return, will it upload? Will it validate? Yeah. Sometimes when you do an when you go do an objection, you get an objection decision when you explain to them that, oh, for example, you have charged me an assessment for maybe rental tax. I don't have any property. Okay. You get an objection decision that says that assessment vacated, cleared. A few days later, you get another additional assessment that is changing an additional assessment. Same assessment number as the objection. You can't object to it. Now, where do you go? Do you go to that immediately? Is this a new assessment? Is it an objection decision? So there's some things about the tools, about the URA. Not saying that everything about URA is bad. I was even debating if I should talk about issues to do with their stuff. It's a tricky one. But not all URA stuff are bad. Some are very good, some are very helpful. But there is a few people, for example, where, as you can see that image, you have seen that with Twagala Sente, Twagala Kutunyonyola, like if you try to go to URA towards the end of the financial year, June, it's clear, it's the collection targets, nothing else, okay? Sometimes the basis of the assessment, some of them are questionable. The customer care, when you talk to them, are they polite? You get it? There's that also the attitude to close tasks. Like maybe it's in your login, you need to close it before the timeline. So you think, okay, someone is missing something simple. Oh, you didn't put your home address. You didn't put a phone number. I reject the tin. I'm amending maybe the profile and adding something. So do I maybe call the person and ask them to clarify, or do I send them an email and get the information, or I just reject? Yeah. People will tell you about TCCs. If you have something that's not very clear, ticking all the boxes, and it may be hard to get it, so it's something to think about. My friends and colleagues at the URA, I'm not saying all is bad, some things are good, but I just thought, because they asked me to talk about the challenges, not the good things. That's why I brought this out. On another day, we'll talk about the good things as well from the URA. The other thing to talk about is from the perspective of managing a tax function for a corporate entity. What are some of the challenges that we face? I'm going to run through the presentation. I know I'm standing between many of you and your lunch, so let me try and move faster. That's a challenge of speaking last. Talent, finding the right people. It's not always easy to find tax people that are well grounded in all aspects. Usually they know one thing or the other. We talked about the frequent law policy changes. I will not dwell much into it. We have talked about the URA. Now, it's one thing to advise, it's another thing to implement. That I learned when I moved into industry. Now, there are many gray areas. Because of time, I'll just talk about some of the hard decisions you have to make. For example, someone has lost a DR1 and you are maybe contributing as an entity to the burial. Is that a taxable benefit? Would you want to give someone something and then they find that their salary is less because you put it in the payee return as a benefit? Yeah. When you're advising, it's very easy. In reality, it's not as easy. So some of the things are not that easy. The culture as well, most people, it's especially with the informal sector, I'll talk about this together. We can't kick them out, we have to deal with them. But let's say you have a small plumbing issue, you get a plumber to come and fix it. And he says, I need 50,000. It's a professional service. Do you withhold from them? Yeah? It's clear the law what it is, but imagine explaining someone you're paying cash that I'll give you a withholding tax certificate after the 15th next month. many of us now have Netflix. You are paying Netflix, they give you a fee, maybe 40k, converting Uganda shillings. Now, will you tell Netflix, it's a foreign payment, I need to withhold withholding tax? Yeah. Would you watch that movie in the evening? Yeah. I've used the Netflix example, but it's the same like for other things. I am buying a license from Microsoft. The fee is put there. Do I have any way of actually even negotiating with them that your payment attracts withholding tax? I'll give the big example. Visa, we all use Visa. Visa actually deducts the bank charges before the money is remitted to the banks. Would the banks even have access to do the withholding tax on Visa if maybe that payment qualified for withholding tax? Just something to think about. Strategies, I'll just run through this. Many things have been said. Of course, you need to hire and train. You do trainings like this also. Farm-wise consultations, I don't know how many people have emphasized this. If you're not sure, consult, get a private ruling if something is not very certain, very gray. Reconciliations, the accountants know what this means. You don't reconcile, you don't know what problems you have. Now, embedding a tax function in all business processes, this is very key. Don't let the tax guy find out last about what's happening. When you're doing the transaction, from day one, let people find out. I'll just give just a small example. We all know Dennis was here, very eloquent. He talked about oil and gas. We had one of the PSAs was signed, and there was something that the minister signed off that there will be no capital gains. URA challenged it. They went to court. Court was very clear. The minister doesn't have power to sign such a waiver. So imagine you are the investor, you have signed this, you have worked, done all this based on that understanding. But the law says otherwise. Who would doubt the minister signing a document that didn't have power? So some of the things to think about, keeping documentation, integration of IT in tax reporting. There's many softwares where, for example, when you're doing payments, it's automatically deducts withholding tax instead of asking for someone, waiting for someone making the payment to deduct the withholding tax. So you automate some of those things. Talking about technology still, URA actually is giving us the free database tools. Let me call them that. You'd find some people that they rely actually on the URA, maybe IFRIS or e-tax for their record keeping. If you make it mandatory for every transaction you deal with to issue you an e-receipt or invoice, so you have already all your documentation kept for you by URA for free. IFRIS has many functionalities that are useful. You can check what you have imported, the value, the HSE codes, many things. So because of time, I'll not delve so much into it. I know many people are already hungry. The key discussion for today, why I think they chose me to come here today, is from a client perspective, what do I expect from a lawyer? Allow me just to say some, maybe be a bit more detailed than on the other things. Now, first of all, when you're giving me advice or when you're dealing with me, I need you to have a holistic view. Don't think about only the transaction at hand, okay? I had thought of many examples, but maybe I didn't manage listening to the first presentation when they're talking about mergers and acquisitions. But I'm buying an asset. Don't be so quick to tell me, okay, let's buy the asset, let's do the transfer. Think about what are the other options that we can explore. Can we buy it as a business purchase? Can we buy it as one unit? It's a going concern. Yeah. When I buy it as a going concern, there's things that could be waived like the VAT. Okay. Things that you can think about. Can I take on the loss if someone, if it's a business, imagine. Things to think about. Don't be so fast to think, okay, what is the fee that I'll get? Maybe if I do the registration, you quote your fee, I'll do the land title searches and transfers quick. Have a 360 view of the transaction. What are the alternatives that I can give? Add value. Don't do only what you have been told to do. Okay. Then there's that thing of one size fits all. I ask you for something, you did it for someone some time back, you just remove the shelf, copy and paste, control find, change the names, send it to me. It's not always that every advice works for everyone. You need to customize it. What are my individual circumstances? I'll give an example. Someone asks you for excise duty. Do we claim input for excise duty that we have incurred? You said, oh, you just say yes. Maybe the person you're dealing with was in a plastic manufacturer. Now this is a beverage manufacturer. The guy who does plastics, because he's converting it to a bottle or something that he's selling, probably can claim the input excise duty. But the guy who is doing a beverage, using the bottle to sell soda or an energy drink or something else, URA would say that it's different from the plastic. So you picking the advice, copy and paste, may not apply to all scenarios. The other thing, and this is very important for me, is progressive litigation. The problem in law school, we're always told that what's your authority, what case supports what you're saying, where is this? So from law school, the 4 years, you don't get the chance to be very imaginative and very, very creative. They tell us to cram the cases, to cram the precedents. You find people quoting what a particular case said, and he knows it, but doesn't know what were the circumstances. Is the fact on all fours? Maybe what did they do wrong in the particular precedent? I'll give 2 scenarios. One of them, not because I was involved, but I really like the thought of the senior counsel, also a lecturer, Joseph Luswata, for the Vivo Energy. There was a precedent we all know from Mukwano, where a lease is not deductible. Their argument was it's an intangible asset. I'll speak to that in future, why the argument was like that. But it's been on the books for so long, and everyone knows. You ask anyone that, do we claim leases? They say, no, it's a capital expense. Mukwano case, that. It's done and dusted. You need to think, how do I progress this? The law school people should give us a chance maybe to also be imaginative. Think of maybe, we used to call it, what's it called? When you compare 2 cases to see if they're distinguishing cases, and find out how can I proceed differently. I like the way they did it in the Vivo Energy. They split a lease premium from a lease expense. Now everyone knows. Of course, some people are saying, oh, these lawyers are doing this, blah, blah, blah. But think about it. Foreign companies, Vivo as an example. You're a foreign entity. In our constitution, you cannot own land. So the only way you can own land is for the lease. But I can never get the deduction. It was something very unfair into that particular industry. Now, we have a bad precedent on the books. How do we proceed? You need to think of, how do I change this? Okay? So when I ask you for advice, don't tell me, oh, there's this precedent, oh, there's this. Think of what was wrong with the precedent. How can we improve it? Okay? The other example I wanted to give is maybe the TAT. We all know Section 15, TAT Act, 30% of the tax. It's a pain. The way I'm objecting is because I don't have the money. There was a creative way of how the guys who did the Century bottling case did it. They said, we have a payment plan. It's been agreed by the URI. We haven't paid the money, but there's a payment plan. And the judge was happy, said, okay. But if you go to a lawyer and the lawyer just says, there's this precedent or there's this other Supreme Court case, there's nothing you can do about it. As a client, I want someone to think about, how do you solve my problem? Of course, we have progressive litigation, but also we need to know when to settle. Sometimes I feel pain when I look at some of the rulings. I was going to use the word obvious, but when there's a predictable outcome, may not be obvious, but a predictable outcome, everything is against you. the act, the precedent, but you still continue. I don't know why. For my own reputation, I wouldn't take on some cases. I'll tell the client we need to go and agree a payment plan or whatever it is. But you fit some of these rulings and you wonder, why did we proceed? So sometimes it's good to advise the client, on this particular matter, let's settle, not just to always go for litigation. The other thing I expect from my lawyer, for example, would be I need alert updates. I'm not in court every day, but you're in court, you have had a recent ruling. Tell me what's happening. And to emphasize, it has to be customized, not one size fits all. Yesterday, Senior Kefas gave us a very good recent tax decisions. You have these decisions, share with your clients, comment about them. Now, that was what I was requested to present. I'll just make a few personal comments based on the discussion that's been ongoing. I would encourage the Law Society to be more aggressive in influencing the legislative change. We have some bad laws, so we need to lobby so that they are changed. We have things that we know that need to be changed. When the bills come out, we need to actually comment. Let the Law Society present a paper to the finance committee in Parliament, showing the disadvantages of what that particular bill is. Not just to comment in the WhatsApp groups and complain, but let's make it a habit. Someone said, I forget his name, from the URA litigation, I think it's Tony. He said that can't we make some soft law like in international? We make comments as the Law Society. This is our position on this particular matter. This is our definition on this particular thing. Collaboration on litigation. Back to the Mukwano case. Any accountant will tell you that a lease is not an intangible asset. That's why that case was lost. So when you're doing litigation on a particular matter, lawyers, we tend to think we know it all. Get someone else to give you an opinion. Ask a tax consultant, an accountant, or maybe another lawyer who has expertise in that area, so that we always present the best cases, well-rounded. Relationships and networks, I don't know how much I should emphasize this, but when you don't know anyone, or it's hard for you to get anything done. For example, if you have a problem at the URI and you go to the reception to ask, you may spend the whole day there and you still come back without a solution. But when you know someone, you can call someone who can help you, direct you to exactly where to go. So I can't emphasize how much you need to network, how much you need to have relationships. Having worked in a Big Four previously, there's power in global networks. Now, there's a lot of referral work that comes from being part of a network. So you're a small law firm, find out what other global law firms maybe have no representatives in Uganda. Network with them. You'll see a lot of work coming through. Many of the big local law firms have changed their names to the brand of the networks they're being part of. Look out for it. It will actually help grow your business. There's a lot of work in advisory that you'll never get unless it comes through a referral. Eminence, we all know articles, thought leadership. There's many things to talk about. Now, lastly, in my comments is you need to know beyond the legal practice. Dennis was talking about the oil and gas very well. It's not because it was taught in law school at LDC. No, you need to go beyond. There is pillar 1, pillar 2. We're talking about Andrew yesterday was talking about these BEPS things and OECD. You'd find some lawyers who have never heard of these things. Now, how do you expect maybe to talk to someone in the oil and gas industry? You're not even on the national supplier database. You don't even know what local content is. Some people don't even know what IFRS is. I ask you for an IFRS invoice, you have even never registered. So really, go beyond the legal practice. Some people, the only thing they have to offer is their PC. So no more than just what is needed no more than what is taught in law school and the cases. Know about the industry. Yeah. Lastly, There's a lot of work. So the question is it tax compliance? Is it for accountants? Something to think about. Can lawyers get into there? How many lawyers are involved in documenting TP policies? A document, that's legal work. Accountants are making a lot of money in this particular industry. I'm lucky to be a bit having the best of both worlds, but not many people. Many lawyers don't even know what transfer pricing is, but this is actually something that should be mainly for the lawyers. Transaction advisory, company secretary, there are many things that you can do as lawyers, but maybe just to emphasize the things about networks. If I was choosing a law firm to deal with, what would be the things I consider? First of all, the reputation. The reputation comes with time. So when it goes to litigation, you'll struggle with people who have been in industry for a long time. But get that one case, do it very well. Everyone will know about it that you did it. The relationships, we talked about it. I don't know how much to emphasize. Then the fees. Sometimes if it's too low, I may think, this guy may not be worth the job. Just investigate, think about it. Quote a fee that is reminiscent of the work that you do. Because of time, I had to rush through. I didn't give many examples. I've been holding many of you, but thank you again to the Law Society for inviting me. And it's been a pleasure and honor to speak after very many senior distinguished colleagues. Thank you.
Thank you very much, Michael. We all agree Michael has really hit home, and Michael, those were very, very important and very truthful deliberations. If I can even give you some of the comments on our Q&A, people are saying, Okubienyo, yeah, we deserve that Okubienyo because it was a wake-up call to we consultants. You can imagine if you're a tax advisor to Michael, yeah, you can imagine how hard you'll have defending your bill because Michael asked what value addition are you giving to him. So Michael, that was very, very important for us. At least you've given us clients' expectations. So you can imagine if you're Michael's tax consultant and you can't even address all those issues Michael was raising. So that's very, very, very thoughtful. And Michael, we're very, very honored that you've really given a wake-up call to all of us. So we as consultants, let's get back home, get back on track and take up this. Thank you very much, Michael. And I think Mike has really addressed each single query in there, and we're very honored. So clients' responses, clients' expectations are very, very key in our work. So Michael, very honored by that, and thank you very much. Ladies and gentlemen, our time is really fast spent, but allow us just 10-15 minutes to wrap up our next session. Our next session is a topical discussion. It's an open forum. So we've been having all presenters all day, but now it's imperative for us to open up the floor and have our attendees submit as well. So we're going to be picking up on some of us to just share our experiences, our thoughts, our comments around some of these topical issues. And I'll be picking up from varied experiences, varied practices. Firstly, I will be having my good friend Emma Tumhaise. Emma is a senior associate at Otas Advocates. Emma, are you still with us? Could you just unmute in a minute or two? Let's have your quick thoughts around key emerging tax practices. What should you take note? What are some of those key emerging trends, whether globally, internationally? So Emma, could you unmute and go fast in a minute or two? Emma, are you there? I think as Emma is getting ready, we can have Ian Mutibwa. I trust you there. Ian is a managing partner at Signum Advocates. Signum has been very, very big on tax and some of these emerging areas like Islamic finance. So Ian, could you just give us some of your key snippets, your key thoughts around any emerging tax trends that we should take note of as practitioners? Ian, you can unmute and share with us. IT, could you unmute Ian? I think he's trying to. Ian, we trust.
Thank you very much, Edwin. Thank you very much, Edwin. Pleasure, and I'm happy for the organization, UNS a lot of things that have been organized in this. Thank you very much. I'll just give me 2 minutes to hint on something topical. I think Michael talked about transfer pricing. I think transfer pricing is one of the emerging trends we have in tax, and we have very few or very limited experience people to do this. And yes, they have noted these documents are done by lawyers. So transfer pricing is not a science, it's an art. You have to explain the transaction, and then the other issues like benchmarking can be done by four other benchmarking tools, but it's actually an art which you can define. But I want to talk about mainly Islamic finance.
It's fresh in Uganda. We've just had a little bit of feedback. All right, it's fresh in Uganda. We're happy to have worked with BDO to put pressure on the changes in the law, and the law probably now gives a little bit of wiggle room to allow for a fair play on taxation of both conventional Islamic finance. I think that's an area we should be interested in, because this is new in Uganda, and there's going to be a lot of litigation coming in, or a lot of advisory coming in for the structuring of a different Islamic finance product, because their structure is a little bit different from the normal banking as you know it. For example, the bank will be allowed to own property, so that they can own land or restrict that property to the lender, and then the lender will be able to get a profit from a bank where the bank makes a profit from that particular thing. So in a nutshell, I think that's one of the emerging areas that tax practitioners should be looking out for, so that we can get the more the merrier, as I always say, so that we can get a good experience in this particular field. I also want to throw a kalango as I'm here. We have a tax conference, tax Islamic finance conference happening next week on the 19th. Please attend online. There's an online option as well. Please attend, because we're going to be discussing things such as structuring as well as taxation of Islamic finance. Thank you very much.
For those humble thoughts, certainly Godwin from the Secretariat is here, and he will pass his invoice for the Africa Lango. But yeah, thank you, Ian. Emma, are you back? Are you available? Emma Tumhaise from Otters.
Hello, Edwin. Can you hear me?
I can hear you perfect. Yes, Emma, you can take it on.
Okay. Thank you very much. Thank you for. They've definitely been very, very informative. So, in a minute or two, the only issue that I potentially want to hint on is on the tax aspects of venture capital funds and these alternative investment funds that we have seen popping up from time to time. I do understand that there is a lot of underground work that is currently ongoing with the efforts of the Capital Markets Authority, Ministry of Finance. I think I've seen some of our colleagues from Ministry of Finance also attending this conference, and also definitely from URA to try and address some of these issues. And previously, we have seen amendments that have been passed, especially in regards to capital gains tax on disposal of shares by these venture capital funds. So it clearly shows the attitude that we are taking on as a country. We understand the role that venture capital funds play, and these alternative investment funds, even beyond potentially the return on the investments that they're trying to obtain. We do get a lot of improved corporate governance from our local companies, which under normal circumstances would not be available from traditional financing models that would have. So definitely the capital gains tax amendment from, I think, about 2 years ago was a welcome addition to our laws, but we do definitely still have a lot of work to do, at least from a tax perspective, to make Uganda attractive for venture capital funds. From back then in 2021, when this amendment was passed, at least from my knowledge, we have had one local venture capital fund that has registered with the Capital Markets Authority, and I think about 2 or 3 others that are in the offing. So that goes to show that with improved investment climate that takes into account not only the legal the legal aspects, but also the tax aspects, it makes it more and more attractive, which in the long run also improves our collection efforts as a country from taxes. So yeah, in terms of the latest trend, I think that is something critical. Otherwise, thank you very much, everyone that attended.
Thank you, Emma. Emma raises very pertinent issues as well. Let's take note of that, practitioners. Gender balance. Let's have a lady as well. Bridget Namboze, I see you've been attending very candidly yesterday and today. Bridget Namboze formerly worked with Cont'D Sempeba, and she's now working with B. Namboze Company Advocate. So, Bridget, yeah, you're very active in corporate advisory and transactions. If you could share with us your humble thoughts on any key emerging trends. Bridget, you can unmute and share with us.
In respect to high net worth individuals. The current trend is for family trust as one of the major tools for estate planning. Our neighbors in Kenya have progressed by having the Trust Perpetual Succession Amendment Act of 2021. And also their tax regime is favorable, that in a way that it allows high net worth individuals to do their estate planning while they're still alive. However, in Uganda, for someone to even set up a family trust, they're not able to under trust. What's still the tax laws, and if you look at Section 71 of the income tax onwards, it's not very clear how useful that can be. To take the example of Council Augustine, that school of 10 acres and a family that is so divided and just wants to subdivide the land, and going back to the president's remarks of why can't we keep the family wealth together? So I think it's something that the tax cluster should consider.
Losing you. No, IT, if you could mute her. Bridget, sorry, Bridget, thank you, Bridget, for those thoughts. We lost you midway, but at least, yeah, the message was driven home. Augustine has taken note, and he'll respond later on, yeah? But thank you for those humble thoughts. Then, ladies and gentlemen, tax practice is a shared space between lawyers and accountants. Yeah? And in that discussion, it's very imperative for us to also listen to some of our colleagues who are accountants. Yeah, they're not lawyers, but they're very involved in this space, and we need to be very open and learn from some of them. So I have two gentlemen who are accountants, and it's imperative for us to listen to them. The first is Mr. Juma Bully. Mr. Juma Bully is a senior manager in the tax department at BDO, and he previously worked with a big four audit firm. So Juma Bully, could you just unmute and share with us what are some of your quick thoughts around key emerging trends in tax for us to take note?
Ledger reconciliation. My colleagues have already talked about it. I had Chambade and Kalima talk about that issue, but I want to talk about it for main about 2 or 3 reasons. Number one is accuracy of books of accounts. We've had cases where you check books of accounts of a taxpayer, and you find that they have, for instance, a tax credit of a significant amount, say 500 million for income tax. But when you look at the income tax ledger they have with the URA, it shows a liability. So you'll find that those books are actually misrepresented, because if you have a tax credit and URA does not recognize such a credit, then that credit is fictitious. So it is very important that us accountants and lawyers take keen interest in this issue because it has far-reaching implications. Um, the second issue that was about accuracy of books of accounts, and it cuts across all tax heads. We've seen many cases where a taxpayer has, for instance, a VAT credit, but when you look at what they have, the other side on the URA ledger, they actually have a liability. So ledger reconciliation is a key issue that URA is using these days. The second reason why ledger reconciliation is very important is it is very important for you to manage your compliance. It is important to keep track of what your ledger balances are, because what happens is that when you have a liability on your ledgers that you may not be aware of, URA is aware of this liability, and they will keep sending you reminders to pay this liability. And if they send you a third reminder and you don't respond, the next issue is that they are going to agency your account. And we all know the implications of an agency notice. It just disrupts your business. So very important to keep track of what is on your ledger. The third reason why you need to keep track of your ledgers is accumulation of interest. For instance, if you think that you have a credit on the ledger and URA shows, and according to URA you have a liability, you may not be paying your normal flow because you think you have a credit. But on the other side, URA has a liability. So they will be allocating whatever you will not be paying, thinking that you have a credit, but URA has a liability on the ledger. So interest keeps accumulating. So ledger reconciliation these days is a big, big, big issue. The other, I will talk about the digital services tax. It is now a big issue, as you know, for both VAT and income tax. For VAT, if, for instance, if you are just consuming services, and these services are directly being provided by a non-resident, for instance, Facebook advertising, and you are VAT registered, you're actually importing VAT. So you are required to account for VAT on imported services. So it is not just, this digital services tax is not just about the providers, even us, the consumers. There are many people out there who are consuming these services and they're not accounting for VAT on imported services. But on the side of the providers, yes, there is an obligation to account for VAT. And you're aware of the recent amendment on the income tax side of a requirement by providers of these digital services. I think Section 86 was amended to include a requirement by providers of digital services to actually even file returns. So we need to take keen interest in that development. The other issues, I think my colleagues have already commented on them. Islamic finance, I'll not delve into that. I had Ian talking about it. And as BDO with Signam, will be holding an Islamic finance conference next week. Thank you, Edwin. That's all I can say for now.
We can't stop preaching the compliance gospel. That's very, very big. Thank you very much, Juma. Mr. John Sebuma. Mr. John Sebuma, are you there? John Sebuma is a managing partner at Sebuma Associates. He's also an accountant, but he's very big also on tax practice. So, John, could you just share with us in a minute some aspects that we practitioners need to take note of? John Sebuma, are you there? All right, as John is getting ready, members, our time is fast spent, but I'll give an opportunity to any of our other attendees. You could simply raise your hand. Yeah, I'll pick up on the same. But there's a gentleman who has been very, very attentive. He's a very busy man, but he's been very attentive yesterday and today. And I think we need to give him an opportunity to share. He's also a senior, very colleague in practice. Council Mohammed Sereko, I see you on the call. I don't know if you're there. If you're not very busy, could you unmute and share with us any key points we need to take note of as practitioners? Council Mohammed Sereko, either. All right, I think he's caught up as well. Then there was my colleague Edman Agawa. Edman is from the URA legal department. Edman, I don't know if you're done with the meeting earlier. Could you unmute as well and just give us your 2 cents around any key emerging issues, key emerging trends in our tax practice? Edman, could you unmute if you're there? Sorry about that. Then lastly, the floor is still open. The offer is still open, ladies and gentlemen. Anyone willing to give us in a minute, anyone willing to share with us their 2 cents on any key emerging issues in our tax practice? What are some of those trends we need to take note of? Oh, thank you, Edward. Edward Ochen has raised his hand. Edward, could you unmute and share with us? Hear you, Edward. Go ahead.
Critically important for practitioners, especially if you work for organizations which have reliance on other if you have a group setup. So for instance, if you're a company registered in Uganda and you're a member of a subsidiary of another organization, and normally you would have what is called shared services between these companies rather. So it's critically important that we document, you guide your finance teams or accounting teams to ensure that they document the services that you render to or you receive from the other colleagues, from the other subsidiaries, because we do have to pay for those services. And so as the government tries to raise revenue all around, they are getting more and more keen on understanding transfer pricing between organizations which have a group setup. So critically important, I think. They will arise very, very often because we do share services and we pay for those services. And as a result, as you know, it's the taxes arise as a result of those services. Sometimes we give the services to those countries. They also come back to you and say, well, give us the documents. They are revenue authorities. So it's critically important that colleagues try to familiarize themselves with those areas, especially now that we banks or insurance companies, oil and gas companies to transact and work together with that company. So that's my humble submission. I hope it's helpful in a small way. Thank you.
Thank you very much, Edward. That's very, very important. We've taken note as well. Then, ladies and gentlemen, I just want to give an opportunity to these 3 gentlemen. They're also senior lawyers, and it's imperative if you can get some guidance or some thoughts around some of these key emerging areas. The first is Council Teres Kavuma. Council Teres Kavuma, I see on the call. There's Council Peter Alan Musoke. Then there's Senior Counsel, so Donald Nyakairu. These are esteemed practitioners, and it's imperative to just listen in on that vast knowledge and experience. So, gentlemen, any of you can unmute and share with us. Our time is fast spent, but it's also very imperative to listen in on your wise wisdom. So, if any of you is in there, you can unmute and share with us. Well, we can hear you.
Disclosure is an area which many people seem to be thinking about voluntary disclosure, but don't know how to go about it. And I think it's an area which, as lawyers, we should focus on and try and assist our clients in getting it done. And I think we are not very much involved in it. We rely mainly on the accountants, but there's a legal element in it, which I think we should be aware of. And it's a trend because URA has been kind enough now to give some moratoriums and to give windows which should be we should try and use. Thank you.
Thank you very much, Donald. Then for the last person, I know I'm ambushing her. She's seated right next to me. Diana Prida, you're from the legal department at URA, and you've been with us throughout the symposium. Yeah, you're a key part of the tax law cluster. Diana, it's also very, very imperative. You're protected. No one is roasting you at this point. Yeah, but URA remains a key stakeholder in our practice. Yeah, so you as a manager in the legal department, just want to give an opportunity. Yeah, in a minute, just give us also URA's take or even your personal take. Yeah, on some of these key areas, but important message to we, the practitioners.
Thank you, Edwin, and I'll just share my opinion and my personal experiences. From the 2-day engagement that we've had, it's really been action-packed, full of information, and the structuring of the whole symposium. Really, I think what has come through for me is the agenda of compliance, the need to comply, and how we as lawyers, I'm a lawyer too, now speaking as a lawyer and a member of the tax cluster and Uganda Law Society, how we as lawyers play a key role. That has come throughout the presentations and has been tied neatly with a bow by the presentation from Michael, which really showed that we lawyers have a critical role to play, and we have to constantly rebrand, relearn, and learn so as to see that purpose come through and see how we can optimize the benefits for our clients if we do the right thing and advise them well, but also ensure that they comply with their tax obligations. It goes without saying that tax is a creature of statute, and there can be no tax without a law, and that cements really our role in the taxation area. So it's ours to make or break. It's ours to create opportunities out of, and there are many. The topical issues coming through about voluntary disclosure, the last one that was highlighted by Councillor Donald, is actually one of the avenues available to us, and shows that there are avenues in place to support taxpayers, which we lawyers have to really look out for, seek out, and advise our lawyers to come through. To briefly speak about URA, if I may, is when Edwin talked about roasting, we really sometimes receive the short end of the stick, and it's always roasting, but it's really that you are in the journey for tax compliance is a partner. We see lawyers as partners. You are partners. When we're in the tax appeals tribunal, it's with lawyers. Where when you're at objection, you're still dealing with lawyers. Wherever it is, if it's in the interpretation of the law, we are lawyers. We see lawyers as a key partner in that agenda. We see lawyers as a key partner in pushing the compliance agenda, one from the onset, advising taxpayers on what to do. We see lawyers playing a key role in bridging the gap of tax knowledge, in terms of educating, because we do realize that there's that gap. We see lawyers as key partners in trying to bridge that gap between us and the taxpayers, of enlightening them. So it's to call upon us as tax practitioners to constantly renew ourselves, constantly seek out those amendments, those areas, constantly see ways how to best advise our taxpayers while ensuring that they're compliant, but also optimizing benefits for them and ultimately contributing to the development of our country. Thank you very much, everyone who's attended, and thank you, Edwin.
Thank you, Diana Prida. That's very, very helpful and important from the URA as well. Ladies and gentlemen, we've come to the close of our 2-day symposium, and we want to very much firstly thank you who took the time, to pay up, to attend, and to come and share thoughts. We're very, very honored to have been graced with your presence. Our dear attendees, that is very, very important. But also importantly, a very big thank you to our dear panelists. These gentlemen and ladies took the time to sit down, take off time off the busy schedule, prepare these slides, and trek their way in here just to come and share the experiences and knowledge. None of them is being paid for this, so that is very, very gracious and kind of them. And in no particular order, Dr. Fred Muhumuza, Ms. Stella Nyapendi from the URA, John Jet Tusabe from BDO, Flavia Subo from Max, Mike Chambade, Andrew Mukasa Chambade, James Nwagaba, Cephas Birungi, Mr. Ronald Kalema, Dennis Kakembo, Augustine Chigundu, Michael Chibuka, Diana Prida, and everyone here who took the time to participate in the Q&A, raise your thoughts, raise the questions. That was very, very good. You made the discussion and symposium very meaningful, and we're very, very honored. And at this point, allow me to invite Ms. Rebecca Nambi. Rebecca Nambi is the head of Tax and Revenue Cluster. She has been at the heart of this whole symposium. She has attended, she's been here, and she's followed up on each of us. Rebecca, if you could just unmute and share with us, and you can close off the symposium.
I'd like to take this opportunity to say thank you. It has been an event marked with profound discussions, insightful presentations, and the kind of understanding between professionals, camaraderie, that exemplifies the legal community's pursuit for excellence. So I want to express my deepest gratitude to each and every one of you who has been a speaker, and also all the attendees for taking out this time. We have had a very good number online, and we really appreciate that. Thank you for your active participation, thought-provoking questions, and your unwavering commitment to the field of taxation. So we see our speakers, our distinguished speakers have shared their expertise and challenged our perceptions, as well as broadened our understanding of the tax law. Their insight and knowledge has left an indelible mark on our professional growth, and I know this is true for each one of us who has attended. I extend my heartfelt gratitude to our host, BDO. Thank you for coming through for us, and as well as to the ULS organizing committee. Thank you so much for coordinating us, and the IT team has been impeccable in delivering this. We have not been hacked. I was kind of worried that we may have a hack, and normally you know what kind of pictures come up when a hack is happening. So thank you, IT team, for actually seeing us through this symposium safely. So as we adjourn, I encourage each one of you to continue to ponder on the things that we have discussed, on the points that we have discussed. But we shall be organizing now an action, another session for not today, but some in the coming month, to see how we can actually take actions, real action, and not just talking about the issues that we face. There's some things that we actually need to act upon. Some were raised yesterday, others were raised today, and we need to put the force of the Uganda Law Society behind those policy changes that we need to see, as opposed to waiting for the policymakers to invite us to give a comment on what their proposed changes are. There are things that we need to actually act on. For example, we need to engage URA as to why it is difficult for them to comply with the Supreme Court decisions in some cases. We need to have engagement with the Tax Policy Department and Ministry of Finance, as we move forward to enhance our area of practice. So with that, once again, I want to say thank you and farewell. The symposium comes to an end today. Thank you very much.